Megan Fox.
And Megan Fox has the story.
Megan Fox.
Megan Fox.
Megan Fox writes at PJ Media.
Eat Tucker.
And that was your last.
Damn it, man. I cried for 2 days.
Megan, thank you very much for that.
So, I can explain the bed thing.
If you don't show up and vote, up your ass. I don't care if you're in the hospital. Crawl to the stake. Crawl there.
It's like Jesus going into the temple. He's like, I got a whip. Get out! Get out! The lovely and wonderful Megan Fox. Not that one.
Not that one. Not the weird one that drinks blood in his toe thumb.
Megan Fox.
Megan. And honestly, Megan, if you don't like it, I'm sorry.
She's the devil.
Megan Fox. Megan Fox.
I've been very nice to you, although I could probably maybe not be based on the way you have treated me, but I wouldn't do that.
You've never met a like me. You want to tangle? You want to go? Holy sh!
Too much cussing on this. I guess we didn't bleep it, so we got to turn it off. But it's
You pissed off the wrong woman.
oh my God, I have been assaulted, but Megan Fox runs wild on you, brother.
She's the devil.
Not for publication.
The story.
I'm Megan Fox. Thank you. Cheers.
Good morning, everyone. Good morning. It's time. It's December 15th. We've been waiting for this day for a long time, and it's here. Today, we're going to be watching Greg Anderson and Nick Whitney and the Plaintiffs team, probably Mr. Elegant, making arguments about the Yahtzee motion, also the directed verdict motions. There's just a whole lot of things that we're going to talk about today. Scott at Recovery Addict, what a gift this man is to everyone. He is there right now. And he is actually going to be letting us take his stream, which he got because he's in the pool. He's going to take his stream and let us all send it out there. I'm thrilled about this. Thrilled. I can't find my how's my button sounds? Are they loud enough today? Because yesterday they were so soft.
China.
Can you hear that okay today? Somebody check the volume for me. But yeah, he's going live in a minute. I've got his channel. So if you guys are not subscribed to his second channel, you need to be subscribed to that. It is Top Mark Media. He is going to give us the feed without the logo. So we're not going to need our twat waffle today. Lawn Crime is the pool camera, but he got in the pool, so he gets to use their feed. Hopefully Scott was up bright and early after spending the night at at Dr. Goodhair's house in, let's see, why isn't this letting me make this bigger? This is weird. Hold, please. What a bizarre thing. Oh, maybe because it hasn't started yet. Okay, well, anyway, this is what his channel looks like, the second channel. It's called Top Mark Media. I subscribed yesterday. There isn't going to be a chat on this one. RA is going to have it run through his channel, but he gave us blanket permission to use his feed today. So I've got my eye on that. But in the meantime, while we are waiting, there are things to discuss. Yes, there are.
The Redditors are having a protest. That's right, we're protesting. We're protesting over on Reddit. We are protesting the plaintiffs win. We want a new trial. We want justice. We want justice.
And it's going to be hilarious. I can't wait to see it. What do you mean? He's live? He's not live on Top Mark Media. Maybe Recovery Addict's channel is live, but that's not the feed from the Yeah, the Redditors are protesting. Let's go over to that real quick while we still have time, because it's hysterical and you have to see this. So for some reason, Reddit does this weird thing that if you look at one page one time, it sends you updates from that page. I didn't sign up to get updates from that awful Reddit page. Why would I? They're terrible people.
Because you are a corrupt person. You're the most corrupt.
And so I don't know how, but I got this notice in my on my phone just because I had been over there one time. And this is so stinking funny. Let me make this bigger. All right, so this is the post. Can we make it even bigger than that? Yeah. Leaving treats at all the nurses' stations at JHatch to let them know we support them. But if you look closely, you'll realize that this is a real self-serving thing they're doing here. So they've got some, I don't know, nuts and coffee and chocolates or whatever. But really, it's just to advertise their protest. Hold on, there's a better picture. I've got a Nick gave me a closer one. Where did it go? This is on my locals page. meganfox.locals.com. It says rally. Hold on, I have to get my Reddit voice.
Rally for justice in support of the doctors, nurses, and social workers. Johns Hopkins All Children's Hospital this Friday, December 15th, 7:30 a.m. to 8:30 a.m. prior to the hearing on the front lawn of the Silvertooth Judicial Center. We are mothers, and we stand with JHatch.
And look at the fist raised. And there's more. Wait, what else does it say? It says something else here. I can't. How do I make it go down? I can't. Damn it. All right, I'll have to look at it on my phone so I can read to you the fine print. Because the fine print is hysterical. Oh, no! Oh, breaking news. We have breaking news. Breaking news. 2 protesters are present, very well behaved. They said hello as I walked by, and I reciprocated. All 2 of them showed up. And one of them is Keisha Shapiro, probably. I knew it. I knew it was going to be a flop. I knew it. What do you mean he's live? All right, hold on. Let me go. Present, share screen. It still doesn't look live to me. I know Recovery Addict is live, but he doesn't have a live feed from the courtroom yet, does he? Because it's not on his other. It's not on Top Mark Media, and that's where we're supposed to get the feed. So I will check Recovery Addict, but like I'm not gonna stream snipe his stream. Hold on. No, he's not live yet, guys. I don't know what you're looking at. Top Mark is online. Well, I have it right here. I have been refreshing it. Look, folks. It's not yet. It's a new stream. Oh, he changed the stream? Wow, that's unfortunate. Let's see. Okay. Oh. We have Maya eating mints. Okay. Interesting camera angle. Oh no, he's having trouble getting set up. Well, that could happen. So I'll monitor law and crime as well, just in case if we have like although it looks like he's okay. Is that his camera that he's got working, or is this the law and crime feed? Hold on, let me check law and crime. Yeah, that's the law and crime feed. Which this is so great. There's no logo. Yay, Scott. All right, I was going to read to you what the rest of that protest thing says because it's really freaking funny. Hold on. We got to read this. It says, okay, so where the fists are raised. Hold on, let's bring it up. I've got the thing in my ears. So see these little people down here with the raised fists? We are mothers. Oh, wait, I forgot my.
We are asking that the verdict in the trial of Kowalski v. Johns Hopkins All Children's Hospital be overturned due to evidence being excluded from the trial and blatant juror misconduct. J. Hatch took care of Maya.
Yeah, they sure did. They sure did. In fact, that really should be read in a different kind of voice. Perhaps this one.
J. Hatch took care of my
They took care of her all right. Kind of like the mafia will take care of Maya, take care of their enemies. That's I think the last the last thing that they said there, J Hatch took care of Maya, made me LOL. I was like, folks, I don't think you know what you sound like. I don't think you understand. I don't think you understand what you're saying. All right, so have my buttons been good? I didn't look at the chat when I asked you about the volume. Is the sound can you hear it okay?
Phrasing.
Can you hear the buttons today?
I can't deal with this. I'm going to nuke America.
Or are they really low? Because if they are, I can do some. Oh, it sounds good. Okay. Good. Yesterday, I forgot to hit the button on StreamYard to take the auto sound off. There's so many buttons to hit, so many buttons. And I always do the wrong thing.
What is my problem?
And I forgot to take off the auto thing, and my voice was so much louder than the buttons. It was terrible. Oh, Dr. Goodhair, there he is. There he is. There's the man of the hour. Do we recognize anybody else in the crowd? Man, that man has good hair. I mean, look at that hair. It's beautiful. It's so beautiful. And he always is wearing the greatest looking suits. Oh my goodness. Jules, I heard that maybe Jules wasn't going to be there. Because it's far away. There's a couple of handsome guys. Good morning, Greg. Good morning, Nick. Good to see them again. I feel like we got the band back together. That's how it feels. I'm so excited. I'm so excited. I can't hide my excitement. We got everybody back together today. Yeah, Anderson's hair is looking good too. I told him last night I was giving him my prescription for him for this morning was more stone crab. Oh no, down to the left here. That's going to drive me crazy.
Just give me a moment to get the computer going.
Uh-oh. There's an echo, a bad echo. All right, I'm going to check. Oh, that's because I have law and crime turned on too. It's the Tuft of Justice.
This is case number 2018 CA 5321 Kowalski versus Johns Hopkins Children's Hospital. Starting with the plaintiff, let's take appearances, please.
Yeah, he doesn't look very happy, does he? He looks pissed already.
We have Tom Elliott and Amy Ferrier, and then by Zoom, Samantha Lawrence and Jennifer Anderson on behalf of
God, why do we only have one ear?
Howard Hunter with Chris Altenberg, Ethan Shapiro, and Pat Crowell for Johns Hopkins Children's Hospital.
I may have to boost the volume.
Thank you. And I assume everybody got the agenda that we're going to follow this morning in the second amended order. So why don't we just get right to it. First topic is going to be the issue of alleged juror misconduct, whether we should be having a hearing, and if so, what the contours of that hearing would be. Mr. Shapiro.
Oh boy.
Yes, sir.
Here he comes. Your Honor, juror number one is a Yahtzee.
Your Honor, I actually break this down into two separate and distinct arguments, either of which would warrant a new trial.
He's taking credit for this argument?
Interview. The first is the duty of jurors to adequately and honestly disclose during voir dire any material issue that could affect their jury service. In this case, juror number one has three material omissions or misrepresentations based on his verdict form, and I'll discuss all three in turn. The first was he was asked on his juror interview question whether he or an immediate family member had ever been a victim of a crime, and he checked no. We've since discovered that both he and his wife had filed an affidavit and prosecuted their stepson for threats and looks like what was being threatened as a murder of both of them in the form of a sworn affidavit to Detective George Richards on March
Is that a crime, though?
2016. There's very detailed statements about this. I think they're part of the record, but if not, if I may approach and hand Your Honor a copy. This cannot possibly be something that a juror would forget to disclose. This was a question directly asked, and as Your Honor and the court would review the affidavit, there's multiple instances in here where both juror number one and his wife state that their safety is at issue, that there were threats made against them that they wish to prosecute. That's certainly something that if disclosed, there would have been multiple follow-up questions and likely a peremptory challenge used. The second is one that we did make part of the court record. Obviously, we apologize for the sensitivity of this, but we have to make it as part of the record that in 2002, juror number one was served with an injunction for domestic violence, of which there's a sworn affidavit of child abuse. That file is obviously sealed, so I can't see what the allegations are, but they are part of the record. That would be something that they would have a duty to disclose both during the questionnaire and during voir dire. This was never disclosed, as Your Honor can imagine. Had that been disclosed, that certainly would have led to a cause challenge, if not a peremptory, if the cause challenge was denied. The third, we learned
20 years prior
20
to
years.
this,
20 years.
The third was in the questionnaire prior to the one given to the witnesses. There was a list of witnesses that may be present, of which there was Deborah Salisbury. Deborah Salisbury, as we've learned and as we filed with the court, it turns out she was juror number one's wife's attorney for her divorce proceedings, the same attorney who represented Mr. Kowalski. That was never disclosed to us either. The case law on this is very clear. Under Rule 1.431, we're entitled to an interview of the juror if there's a reasonable basis. I'll get back to that. But I think the controlling case law on this that's really undisputed is the De La Rosa case for the Supreme Court of Florida at 659 Southern 2nd 239. There's a three-part test utilized to determine whether a juror's non-disclosure of information during voir dire warrants a new trial. The first part of the test is that the complaining party must establish that the information is relevant and material to the jury, to the jury service in this case. All three would be material and relevant, but certainly in a case where there's allegations of medical child abuse and a juror has been served with an injunction for child abuse, that's something that we would have to know about.
Sorry, it was blurry. I'm trying to make it not be blurry.
The fact that there's only one camera when you can clearly see like 6 cameras in the courtroom is pretty dumb.
Why is this happening now? I guess I shouldn't have done that.
Wi-Fi, that's...
Sorry, guys. Come on! Damn it. There we go.
Of those individuals.
I haven't gone back through all the voir dire, but...
Well, you're making...
Wait, we have to go back so we can hear what he's saying.
You can use the left and right arrow keys, and it'll go back 5 seconds.
Were there other juror questionnaires where the juror checked family members been a victim of a crime, and then did your side ask questions of those individuals?
I haven't gone back through all the voir dire, but...
Well, you're making a statement, a very express statement that you would have used a peremptory challenge, and I'm just wondering if it was so important when that question was asked.
Chat's so mad at me right now.
What did you do?
The law on what I'd have to go back to my voir dire questions and see what would happen, but I know that in each individual, for the questionnaire, all of these were asked by the court, if you recall, and that the court asked those questions. If we had follow-up questions during the individual sessions, we would have asked them if it was material to the case. Certainly, if somebody was saying they were a victim of a crime involving another family member, I absolutely represent to the court, that would be something I would have followed up on. We had no basis to, and in fact, the case law says under both State Farm Mutual v. Lawrence at 65 Southern 3rd 52 and Westgate Palace v. Parr 216 Southern 3rd 747 that the counsel is not required to delve further into questions on the questionnaire if the answer is no. So there's under the...
It's not me. I didn't touch anything. Okay, that's all right. We can skip over to law and crime.
On cock.
Another family member.
We'll have to bring the twat waffle out.
Disclose that at the front end is sufficient to award a new trial. So that's my argument on the non-disclosure, and at this point, Your Honor,
It might be a little fuzzy just because it's focusing on him and not the judge. So.
Right.
We would phrases improper influence, if not jury tampering, from the outside. And so, you know, we put together a very detailed PowerPoint presentation that we filed as part of our motion for new trial regarding the social media postings of juror number one's wife and how those correlate to what we believe is a very real belief that that information influenced and was known to juror number one during his deliberations and during the trial. This has been noticed as non-evidentiary, I understand, so I'm going to try to move along. I didn't bring the PowerPoint to run through it since it's been filed with the court, but I do want to lay for the record the timeline of this.
Are my levels good?
I think if the court sees the
I just
timeline
fixed
of
you.
this,
Okay.
you can see that the alarm bells are really ringing. If we go back, even if you start with what
I didn't
we
touch
filed as a
anything, I
record,
swear.
the juror question that was filed on October 12th
You want me to present?
with the Sally Smith's name spelled in the
It's okay.
SS logo, and we filed that with the court. We're not accusing juror number one of being a Nazi. But
Let me ask you about
yeah.
Oh boy.
every single juror question.
Here we go.
My habit was to read the question at sidebar, and since I'm right-handed, I would use my right hand and turn it over, and almost always I handed it directly to you to look at. And so not only did you hear the question, you had the opportunity to
Yep, I knew he was going to
look
say this.
at the sheet. And then about halfway or 2/3 of the way through the trial, your side asked for a copy of all the juror questionnaires. That same day, I had the clerk provide them to you. So you had them. So why was this not addressed in your motion that was made?
Because it's,
you know,
because it's
you waited
bullshit.
a couple weeks, but then you made a motion to disqualify the juror, but said nothing about this. So how is it that this issue isn't waived even before we get to the merits of the issue?
We frankly did not appreciate the difference in the lettering, Your Honor. Had we appreciated, we would have raised it.
I don't understand what you mean. You couldn't tell that the yes was different than other questions, or you didn't know that this was in your mind what you're so definitively saying is evidence of juror number 1 calling Sally Smith a Nazi. So, I mean, what is it?
Well, with respect, Your Honor, I don't think anybody, including the court, appreciated the difference in the lettering in the moment. Had we done so.
Well, your second supplement is extremely definitive. And so I'm wondering, 1, why is this issue not waived? And 2, what is the good faith basis for the statement and the assertion you made, or actually Mr. Hunter made in the motion?
What other plausible explanation would there be for distinct lettering for Sally Smith, especially in the eve of Mr. Anderson giving interviews to Court TV accusing the defense of following the Nuremberg defense of we're just following orders? Had this been only an isolated situation where one juror question has
that was their
lettering,
defense.
In the absence of any other,
And the jurors tasked with analyzing the credibility of each witness as they see them.
share this court's view that would be an extrapolation. But
my recollection is that you all made a big stink
Yo.
about Mr. Anderson's interview that next day, and we had to talk about it and discuss it. So I don't see how you can say you didn't appreciate the issue when you physically saw the questionnaire and you were later given it during the trial. So why is this issue not waived?
These issues are, from a legal standpoint, a procedural standpoint, the motions for new trial and requesting a juror review are preserved as long as they're brought within 15 days. There's no legal obligation that we can see that all of these issues need to be timely brought during the trial. Now, certainly, Your Honor, had we appreciated it, we would have added it to our motion. But given the breadth of it, I did not appreciate the different lettering at the time. That's all I can tell you. And it sounds, I don't think the court did. It wasn't glaringly obvious to us as we're reading questions from the bench and focused on the substance of the question.
Well, how
I
did
hope
you come to
Anderson brings up Reddit.
appreciate the
I really do.
difference?
Somebody pointed
Me
it out
too.
to me.
You can continue.
On October 19th, we put a lot of the social media postings of juror number 1's wife. And look, spouses of jurors are entitled to opinions. That's not the issue. The issue is a lot of what's posting here. And I don't think the plaintiff is going to argue in rebuttal that her postings are not extremely pro-plaintiff.
All right, play yours. Brad.
Yep.
Turn your volume on. We can't hear it.
I appreciate the different lettering at the time. That's all I can tell you. And it sounds, I don't think the court did. It wasn't glaringly obvious to us as we're reading questions from the bench and focused on the substance of the question.
Well, how did you come to appreciate the difference?
Somebody pointed it out to me.
Who?
You can
Who?
continue.
Reddit.
On
Say it.
October 19th, we put a lot of the social media postings of juror number 1's wife.
It was us on Reddit.
Spouses of jurors are entitled to opinions. That's not the issue. The issue is a lot of what's posting here. And I don't think the plaintiff is going to argue in rebuttal that her postings are not extremely pro-plaintiff. That's not even the issue directly here. The issue is, given the hostility of juror 1's questions and timing his questions to what she's posting online, gives a very strong presumption that they were communicating. Starting on October 19th.
No, there
juror
isn't.
Number 1 juror number 1's wife was posting online about the lineup for the next day that included Detective Stephanie Graham. And then the next day when Detective Graham's on the stand, she's posting in real time on social media that her husband's going to have questions for Detective Graham.
Well, let me ask you about this. Because anyone who was at the trial knows juror number 1 was basically going to ask questions. Maybe not as certain as death and taxes, but probably as certain as there's going to be a traffic slowdown on I-4 around the Disney Champions Gate area. So how is that evidence of inside information?
Judge, again, if this is the only instance of juror number one's wife predicting who he's going to ask questions to and when, again, in isolation, if that was the only issue, I would appreciate it. But as we lay out, there's about 15 more instances that combine with it. You know, when, and even in, you know, again, in real time, I appreciate the court shared the email from the woman from South Africa questioning the integrity
because, you know, she's only
the Kowalskis. We call her the agent, regardless of what she is. She's, you know, you remember Jules in the courtroom. She's been online saying she was texting with Maya, texting with the Kowalskis. She's calling into YouTube blogs and saying what the jurors are thinking. And, you know, that email was shared with the court. The court shared it with us, but as part of the email, when you look at it, she's talking about juror number one shaking his head hostilely towards the defense witnesses, that Jules is calling into the talk show saying that that they're hostile to all of the defense witnesses. And, you know, you get to what I think is very glaring was the October 26 questions when Sally Smith's video was played. I'm sorry, when Sally Smith took the stand. If you look at what juror number one's wife is posting online at that point, and she is, you know, again, I don't need to establish the pro-plaintiff bias, but it's concerning to the defense that when you look at her social media follows, it's not just the pro-plaintiff blogs. It's the Take Care of Maya producer. It's Mr. Anderson's jury consultant. And she writes on October 27th, I think Sally Smith only relied on Tampa General to decide this case. At the same time, her husband's asking the same questions that Your Honor may remember Mr. Anderson was complaining to the court. We need to clarify that the 2015 Bonnie Rice call was different than the 2016. When you look at his questions, they are, quote, why would Dr. Rice, a TGH doctor, need to call you, Sally Smith, about Maya when you're over at ACH? And then he asks the second question.
How's that?
Why is Bonnie Rice calling you to raise the red flag? They're sharing the same questions and the same concern and the same confusion. You know, again, when you fast forward.
Well, from a timing perspective, didn't juror one ask the question first?
I don't know. I can't tell. It's the chat who's complaining.
From,
I boosted it to 150.
I don't know what to call it, the public, you know, trying to discern what the question meant.
They were made at the same time, yes, sir.
No, which one was first?
Check the private chat link too, because maybe Scott's volume is higher.
So assume that the statement was from somebody other than the wife.
Yeah, it is a little bit.
All right, why don't we switch?
I really think is concerning. You know, we filed the video of the court of juror number one's wife sitting next to Jules in the courtroom. Again, there's this justice system requires not just obviously that the jurors be sequestered from outside information, but it requires the appearance that everybody participating in this tribunal is fair and impartial. I find it impossible to believe that, and I'll say it, that the Kowalskis didn't know at that point because Jules is texting with him and communicating with him that she didn't just spend the day with juror number one's wife. And that when we made the motion to disqualify juror number one for our feeling that he was no longer fair, that he was no longer impartial, somebody has a duty to let the defense and the court know, hey, by the way, his wife was in the courtroom. She's posting online saying, my new best friend is Jules. She's posting in chat rooms saying to one of the bloggers, check out the burner phone with regard to information we have about
the burner phone.
And they're making plans to go to dinner. I mean, you know, at some point, just the appearance of the foreman of the jury's wife sitting in close contact with the agent of the Kowalskis is wrong. And the idea that this can go on unbeknownst to the defense and known to the plaintiff, that ultimately culminates in a motion that we brought in, I believe, November 6th, asking for the disqualification of juror number one And Mr. Anderson, as you remember, went back and forth on it. I think I'd have to agree with this. You asked him, in fairness, Your Honor, do you want this as an appellate issue? And Mr. Anderson said, no, I'm going to substitute in the next juror. And then he went to Mr. Kowalski and said, they had a conversation. Obviously, we're not privy to the conversation. He said, based on the conversation I had with my client, I have to go with his wishes and keep him on. At that point, we believe it has to be clear that they knew that his wife was in the gallery. What Jules may have told them about what conversations she had, we don't know. But we're entitled to an interview on this subject to find out.
Well, let me ask you this. Assume for the sake of argument, I agree with you that from an appearance standpoint, or maybe the cumulative nature of the instances that you have laid out, suggests we need to have an interview. What type of parameters would you recommend be for that interview? Right,
and Your Honor, honestly, I've never had to make this request in my 20 years as a trial lawyer. I will say I understand what we're asking for and the consequences of this. I completely understand the need to respect the judicial process and the jury process and not pry into their lives. I've never called a juror. Obviously, that would be improper and illegal. Their deliberations are theirs, but in a situation like this, with the totality of what's going on, we obviously need not just an interview to see who said what to whom, but the problem is either one of them could just frankly say, well, we didn't talk, and that can't be the end of the inquiry. I would like to know, since juror number one's wife and Jules were in close contact, apparently new best friends, texting about the trial, talking about boyfriends, I'd like to know what the communications were. And, again, I know it's a big request, but we'd like to know what text messages were going on between them. If the court wants to view them first, and
he wants Jules' phone.
Is there anything there, and you can tell us. I don't know any other way to do this because otherwise, he at least according to his own social media post, he's been in contact with Mr. Anderson, who's told him not to say anything. So he's lawyered up to that extent. He's going to be. I'm not suggesting the plaintiff's counsel would ever say to him anything other than tell the truth. I'm not, but he's been lawyered up at this point and advised multiple times that if you say the wrong thing, you're going to throw out this verdict. So I don't know that we can just rest on the assumption that if the court were to ask a series
He's
of questions,
been advised.
did you
By
consider
who?
any outside
YouTubers?
influences? Did you hear anything? If we get frank denials at that point, that would satisfy the inquiry.
My advice is not legal
In this
advice.
age of social media where our primary concerns came from social media, we believe that the proper remedy would be some type of inspection of electronic devices to see if communications were made between him and his wife regarding the trial, to see if communications were made between his wife and Jules or other agents of the Kowalskis, and to see what they're talking about. Because of course, if there's a text message that's going on between, for example, juror number one's wife and Jules that says, don't worry about this, he's going to vote for you, that would be massive, and that would be grounds for a new trial. So our request for this would be the interview. We would certainly defer to the court to the grounds. We're not looking, we suggest it would have to be on the record with people with the chance to examine it, but we believe there has to be some type of an inspection, and the court can certainly control it. We could draft what we would propose as an order if the court were inclined, and I would respectfully suggest that we've more than satisfied our burden under Rule 1.431 with my sworn affidavit, with the evidence we put forth here and more. And I would suggest that I would get with my appellate counsel, Mr. Altenburn and Mr. Hunter, and draft a proposed order that would encompass what we believe would be the scope that would include not just an interview, but some type of an inspection of electronic devices.
Thank you, Mr. Shapiro. Who from the plaintiffs?
Your Honor, if please the court, we'd like to break up some of these arguments because I was there at the time, but the legal arguments would be handled by Mr. Elliott.
I'm going to try to keep us to one attorney per issue. Okay, so
To the extent the court then...
if I've got questions, I know how to ask. So, Mr. Elliott, let me just start.
No, Greg, please.
what the defense has put forward in their motions enough for us, from a appearance of impropriety standpoint, to go ahead and have a juror interview of with some parameters to be discussed? I mean, isn't that what really we have to do at this point?
Your Honor, we would say no.
Why?
Several things. First off, and they've got several different components here, but all the stuff that's in the original motion, the supposition, attack by proxy, they must have done this, they must have done that. This thing was on live the entire time. Everybody saw what was going on. They're assuming things that they can't prove, as we point out in our response. As we also point out at the very beginning, they've waived all of that because it was all available for them to see. We know from what we've submitted to the court, Mr. Shapiro was online. We know his wife was extensively online. So if we're going to assume that wives and husbands talk, which is what they want you to do for the juror who was told not to talk with his wife, we have to assume Mr. Shapiro and his wife were talking, and he knew all of this stuff in real time that was going on, and they do nothing about it until after they get an adverse verdict. So all the stuff in the first one, I would say, is gone on that basis. And then we go through each of them and tell you and explain why. For example, the creature comforts. That was, contrary to what they represent, that was said before the question was asked. It's also a very common phrase, as we point out. So each one of these things has a logical explanation. You can't put together 15 things, if that's what there are, that have no significance and say, oh, now we've got a big conspiracy. Okay, so that's why we said the first motion, gone because of that. The second one, with regard to the 2002 notice, over 20 years old, case law is very clear, that's way beyond the time to be relevant to anything. You also can't tell anything that went on from it.
I mean, what if, and I guess it's just a what if, what if it involved, I think it was probably HRS at the time and not DCF, but right. HRS at the time, and he being juror one, harbored some view of HRS that he brought forward. Isn't that something that the defense would have been entitled to know about?
Your Honor, we don't.
Why would we have asked the question in the first place on the questionnaire if that wasn't something that we were concerned about?
Your Honor, from what they've submitted to the court, they haven't gotten to the threshold issue of showing anything that went on. I mean, we don't know if he was the complainant or maybe he was the subject of it, but we don't know anything about what was involved there. There's just no background. Plus, it's over 20 years old. Case law, we've cited some cases where things were much less time than that, and the court said that's not material at that point. It's too old to be material. And of course, this is not a case against DCF. If he harbored something against DCF or HRS, maybe his ire would have been directed toward them and not the hospital. It might have been good for them. So, this is all an after the fact trying to get out of what happened. That's what this is all about. The juror two supplement on the writing of the lettering, I think the court has dealt with that.
Yeah, I wonder, do they know that?
But if we're talking about using the letters, I have a demonstrative exhibit. Okay, these letters are commonly used for a long time. Okay, it does not mean it's a Nazi symbol. From what I've read online, two of the founding members are Jewish in this group.
Demonstrative.
So, I think that should dispose
and he
of that.
showed
Then
the
we
camera.
This morning. We've seen this is the first time that we've seen this.
Good move, elegant.
First time we've seen this. It does not, from what we can tell from here, and there's no follow-up. There's no, here's a conviction, here was a prosecution, nothing like that. So we don't know if there was any kind of conviction on this.
What are we talking about?
We're talking about this affidavit you got this morning about a threat by apparently juror one's wife before they were married. It was before they were married. It's a threat by her son or stepson. Anyway, first time we've seen this, it does not show, there's no follow-up. There's not showing of any conviction. There's not showing of any physical harm, any physical crime being committed here. This is, again, just a lot of grasping. It's, again, trying to attack by proxy. Who knew who in the courtroom? Really? I mean, if this goes where they want it to go, you're not going to have any more married jurors because there's going to be a presumption every juror speaks with his or her spouse. So that's just too much reaching. As far as the materiality goes, they said, well, they didn't disclose, so we've met that. No. To your point, Your Honor, they have to show it was material. It's a three-part test. Even if there was a blatant concealment, it has to be material. And when you don't ask any of the others, and they can't come in here and tell you, oh yeah, we asked everybody that listed this, we asked them. They haven't gone back, they haven't even done that exercise, I think because they know it wouldn't support their view. But what really happened here is they didn't ask juror number one anything because he had a law enforcement background. They were happy to have a law enforcement person on the jury. They're generally conservative. They liked him until, I guess they didn't like some of his questions as things went along. We had the earlier motion, which was properly denied. So I'm happy to try to answer any of the questions, but we don't think there's enough here to do anything.
Well, assume for the sake of argument that I feel that there's a need for a juror interview. So make that assumption. All right. What is the scope? What are the contours for that interview?
I think it would be clear that you would conduct it, Your Honor. First off, we're not talking about the deposition. We're talking about the court conducting the interview. When I've been through this before, that is the way it's always been done. You don't let one side or the other have their way with a juror in a deposition setting. So you would conduct any discussion like that. It would have to be very limited. I mean, this business about I want to get into all the text and all the stuff, that would be unprecedented. Every time after this, there's an adverse verdict. You're going to hear people saying, "Oh, okay, I want to get that juror's text with his spouse or his cousin or his best friend or whatever." I mean, where are we going to go with this? I guess and I think you do. You ask these jurors every time when they came back, every time. Have they followed your instructions? Have they not discussed the case every morning? They all said yes. I mean, I don't see why an interview would be any different on that. I mean, but that would sort of be the scope of it. I mean, I don't think it's clear you cannot, that no one, the court nor us, can delve into the jury deliberation process.
Well, I mean, I guess I'm with you on the thought process is probably something that we don't or shouldn't go into, but if we're talking about a alleged violation of the court's instructions, that's kind of extrinsic to the thought process. It's, did he receive information outside of the courtroom? And isn't that something that we should know about?
And he's already told you
by
he did
going
not.
through his texts?
Repeatedly.
No, Judge, no.
I suspect if you ask him again, he'll say the same thing.
And you are not to go through his
They're probably right
texts.
about that, but I don't think that gives anybody carte blanche to go delve into everybody's personal information.
Privilege. Come on, get to the spousal privilege.
Again, all the things that they talk about in their first motion, which would lead to the interview, that they claim should lead to the interview, are all things that were publicly known. They are charged with knowledge of that. It was on the internet, all those things. They saw who was sitting in the courtroom. They saw this person, and they saw the juror's wife. They saw them sitting here. Okay?
Well, to be fair, did they know who that person was at the time?
I think they knew who Jules was. That's pretty clear, and it's pretty clear from Mr. Shapiro's wife's posts. They knew that. And I have to assume Mr. Shapiro and his wife were talking.
Well, if you were his wife, would you want to talk to him? I don't know. That's a toss-up, Mr. Elliott.
It was an arranged marriage.
Mr. Elliott?
Not unless you have any further questions.
Well, let's talk more about the scope and contours of
Please
the juror
bring up
interview
spousal
if we were to
privilege,
have one.
Elliott.
So you're suggesting that the court is the one asking the questions?
Unquestionably, Your Honor. I've been through two of these before, and that's the way it was always done.
And I'm assuming here in open court?
That was not how it was done before. It was done in chambers with counsel present. I mean, you still have a juror anonymity issue, I think. But I haven't researched that. I haven't, I'm just saying how it was done before.
My recollection from the papers is the defense have put forth that juror number 1 has identified himself publicly as juror number 1.
Well, I think they outed him first, Your Honor, but
No, he outed himself.
I don't know which came first.
He outed himself
and so
first.
the court were to conduct it, and what are the limits?
I think you can add, I think it would be limited. I think you would say there have been allegations made that you were communicating during the trial information that, that you were discussing it when I told you not to. Is that true?
Anything else, Mr. Elliott, you want to tell me?
I don't think so at this time. I don't have any further questions.
I don't have any further questions for you. Okay. Any very short rebuttal, Mr. Shapiro?
Any questions for me, Your Honor, in light of what Mr. Shapiro raised?
I'm sorry, no, I don't have any questions for you, Mr. Anderson. Now, I don't know yet what I'm going to do. I intend on resolving whether we're going to have a juror interview sometime next week. So I will do my best to get an order out. But for now, this is not saying we are, but if we're going to have a juror interview, let's talk about when it will be. I think I put in the prior notice that it would be the week of January 2nd. So.
Great, more content. Thank you,
what
Judge.
About January 3rd, it's a Wednesday.
I'm fine with it.
The attorneys be available on January
3rd sounds like a plan for me.
Judge, we would still be out of town until the...
Oh, not going to be the 3rd.
Hang on 1 second. I could appear by Zoom for that.
No, not by Zoom, Greg.
The defense can make themselves available.
On the 3rd?
Yes,
Mr. Elliott?
Yes, Your Honor.
Mr. Altenburn?
Looks like it's going to be the 3rd.
It will if we have one, it most likely would be on January 3rd. I don't know what time. We'll figure that out if we're going to have one. So
okay,
let's move
if
on
he's going to do it.
The next topic on our agenda, which is the topic of a renewed motion for basic JNOV. Renewed motion for directed verdict, notwithstanding the verdict, or whatever it's now called.
I still think of it as a
JNOV.
JNOV myself. And
he was never going to rule on this
point out
today,
you've
guys.
divided my very long motion into 3 parts of 15 minutes, and I could spend much more time than that, so I'm going to have to just identify fairly specific things that I think are most important that I would like to address in this first section.
I've read everything. I mean, I didn't read this affidavit yet, but I will.
And so I want to focus on the motion for directed verdict as to the intentional infliction of emotional distress resulting in suicide. I want to briefly discuss the insurance fraud motion for directed verdict, and finally the motion for directed verdict as to the punitive damages claims against the hospital. On the intentional infliction of emotional distress causing suicide, I mean, it's now, you clearly understand that this has to be extreme and outrageous conduct that's atrocious to the point that it's no longer acceptable or cannot be acceptable in a civilized community. The plaintiff admits that no one event was enough to trigger that standard here and is wanting to use a series of things. And now is claiming, although it seemed to me during the trial and otherwise that there was no conspiracy or group of people planning this at the hospital. It felt that way at the time. But now they're just saying it was random people in the hospital that did these things that rise to the level that when communicated by her husband to her caused her to commit suicide. The first thing I want to argue is that my first jury instruction proposal to you was the correct standard, that a common law court expanding incrementally the common law, should restrict this claim to one in which the intentional infliction is done for the purpose of causing suicide. And if that were the standard, we wouldn't have even had a trial here at all on this. And respectfully, if we are to go beyond that public policy to something where something that's even a substantial factor ends up being a matter that causes 100% responsibility under an intentional tort, where we can't claim that she was comparatively negligent, we can't claim that we're entitled to contribution from DCF or anyone else. If that's to be the law, that should be the legislature that does that. That's a step beyond what a common law court should do. So I'm asking first and foremost for a directed verdict, because that was the standard that should have been done here. Now, if you reject that, then we go on to how we actually tried this case. And what I have pushed repeatedly is to, because the pleadings were never a plain and simple statement that said, on this day this happened and it was extremely and outrageous conduct, and on this day this happened and it was extreme and outrageous conduct. Instead, they tell their story with lots of adverbs. And so the question has always been, well, what are these things? What is it that's so important that it causes this to be intentional infliction? And in their response on page 84 and 85, they say that the defendants ignored Beata's request to have Beatty removed from Maya's care. Well, that was the negligent supervision and negligent retention claim. You're quite familiar with what the evidence on that was. There's nothing in there that rises to extreme and outrageous conduct at all. She was the most experienced person with DCF cases, and we kept her on this because it was a complicated DCF case. That's not something that's not tolerated in the civilized community. The next one is then that we allowed Ms. Beatty to molest Maya in the chapel. Now, we've been through that multiple times, and you know that that's not the evidence. You didn't even allow punitive damages on that, let alone to go to the jury on this. So that's not proven. It's a distortion of the evidence, and it's certainly what is proven that didn't even allow for punitive damages is not enough for this count. Third, they say, we refuse to allow court-ordered visitations by phone and FaceTime. Isolating not...
Let me ask you, because on punitive damages, there has to be that next step of, upper management, knowing, ratifying, whatever the statute says.
Correct.
Are you suggesting that the punitive damage standard is engrafted onto the intentional infliction of emotional distress cause of action?
What I'm suggesting is the Supreme Court has said that it's not enough for it to be punitive damage level. It needs to be more than that to constitute intentional infliction of emotional distress. That's from the very first case discussing this that they've said that. We've said that repeatedly.
But what I'm saying is, so you're saying that there has to be a upper management individual either directing or condoning, ratifying the specific conduct, as opposed to someone who's not as high on the food chain doing it?
I don't know that I'm necessarily saying that, but what I'm saying is that the testimony from Maya about what went on in the chapel was not molestation. It was she put me on her lap and she hugged me and I didn't want to be hugged. That's not molestation, and that's not conduct in that context that's extreme and beyond what a civilized community expects. She may have been unwanted affection, but it is not enough for this tort. In the next one, when they say that we refused visitation by phone and FaceTime, you heard various times when they were on court-ordered visitation. You've heard how complicated it was for us to try to comply with the Chapter 39 requirements on this. And as to FaceTime, they're flat out wrong about this. They've made claims that after December, I think it's 28th, that we didn't do this. But if you look in the record at Exhibit 1001, pages 1985, 1982, 1981, 1787, or in their exhibit 2277-628,
2277-628.
628. You will see multiple records discussing the difficulties we were having and that these things were taking place. That in fact, we have the one from page 1985 shows that these are taking place on January 3rd. They took place twice on January 3rd. There was one on January 5th, the day before she committed suicide, that are all in the documents. And the earlier documents show that at the very beginning of this, in December 31, they're fighting about, well, is it 1 hour's worth of time or a half an hour's worth of time that she gets in these? And she wants it moved from one time to another time, and they're trying to accommodate her with that, and they're working with DCF on that with the social workers. So there's all kinds of evidence that shows that the FaceTime stuff was going on in that time period, and there's no testimony I can find from Mr. Kowalski or anyone else that says that's not the case. One of these says that Mr. Kowalski himself was present for one of those calls, that he was in the hospital and that her mother was at home. So there is all kinds of evidence on that. Then we have that we refused to facilitate family therapy sessions ordered by the dependency court.
Oh no!
Lawn cut problem.
Is it?
Now you will recall that the judge in the dependency court sometimes didn't get his orders very clear. We had to actually clean up a couple of things. So one of them was he said she couldn't be in the hospital, and then later on there was this spot that said, well, the family can attend therapy sessions. It was an ambiguity in the order. If it was to be cleaned up, it was to be cleaned up by the judge in the dependency proceeding. They never asked for that. The fact that we didn't honor this is not something that is extreme and outrageous conduct on our part. It just doesn't come close to that. And finally, they say we ignored Beata's medical decision-making rights that had been preserved for the dependency court and tormented Beata further by threatening to remove Maya's port. I'm sorry, going to the port, we suggested it would be a good idea. I think Sally Smith did the same. And Beata refused to have it taken out. That's all there was to that. No one was threatening her with anything with that. As to the medical decision rights, she did retain certain medical decision rights, including the one not to take out that port. But she also was in a DCF proceeding that was accusing her of medical child abuse because of the treatment, including the ketamine that she was doing. So the notion that she had a right to say, I'm going to do whatever I want, even though there's a DCF proceeding going on, that we should be compelled to do that as something that no one would not honor in a civilized community. That is absurd. So the things that they have listed here don't fit that. I could go on with the rest of them, but I'm going to run out of time. They were things like we wanted an open door when her male lawyer came to the hospital without anyone else, and he wanted to be in the room with her alone.
Oh,
There's a laundry list of things that they say this way, that we negligently changed her diagnosis from CRPS to something
Denying
else.
a patient access to her
and the
lawyer?
last
Yeah,
thing
that's
they-
kind of
they
a problem.
But he's a
about
male and he wanted to be
is that,
alone with her, Brad.
You know, they talk about
I mean, Beatty wanted to be alone with her too, and we see how well that
we
went.
intimidated her because of all the things that occurred on January 6th, none of which she knew about. That is undisputed. So these things, even if you're looking at Maya, it may not be enough for intentional infliction, but what they're claiming is that these things, when communicated by Maya in some fashion, we don't know the details, to Jack, who took them home and told them to his wife, got her so upset that Jack didn't come back and tell the hospital about it. Jack wasn't even concerned on the day she committed suicide that she would commit suicide. But we were supposed to have foreseeability to know that what our people were doing, not as a conspiracy, but in this random approach, was enough that we caused her suicide. And I am sorry, that is just not the common law of the state of Florida. We are entitled to a directed verdict on that. We were entitled to a summary judgment on that claim. That is simply not something that they have proven here. Now, as to the fraud insurance, it's a small claim, but it was a claim of intentional fraud. And that is in terms of what The jury was told that there was a fact question about whether we intentionally defrauded them with the insurance. Now, I put in recently just the testimony from Mr. Kowalski about the insurance. There's just a few pages of that. And you know that they didn't actually even put in the bills to begin with. They put in the 3 years of medical processing by Aetna. They never called anyone from Aetna to say there was anything improper about the billing. So they're not charging a breach of contract, but even if a breach of contract were the issue, they'd have to prove up what their damages were. And so here they're claiming that somebody in our billing department put a number on a bill with the intention of defrauding somehow Mr. Kowalski or the insurance company, when the insurance company is not claiming to be defrauded. And that person knew that it was a false statement to defraud them, even though if you look at the medical records, we were providing physical therapy, occupational therapy, cognitive therapy. They're complaining we didn't do enough cognitive therapy.
All 3 hours.
But those are all things that would be done for CRPS as one of the options of a diagnosis. When you go beyond that, and he says, well, it's because I didn't pay a copay. He presented no proof, and he admits in his testimony he has no proof of that. He has no proof we sent him a bill for a copay. The statute of limitations for trying to enforce it by a lawsuit has long since expired. There's no evidence of that. There's no evidence that the deductible was somehow spent on this as compared to everything else that was paid. Those bills were predominantly for 100 days of service in that hospital that we were required to do because the court wouldn't let her out of our hospital. So those things are simply not proven here. As to the extra insurance costs, the only thing he ever did was say that his COBRA bill was higher. Well, that's because his wife no longer had group insurance. It has nothing to do with anything on the coding of a bill from us. So we're entitled to a directed verdict on that claim. Now, finally, on the
Judge is writing his notes. I'm tired of listening to this guy.
Damages. I'm going to start with, I've got limited time, so I'm just going to aim first at the first week. In that first week, and I'm looking at the first stage of the punitive damages. You heard the doctors, what condition she was in. There's no dispute the first day she was in tremendous pain. She was sent there by her doctor, and they began treating her in the emergency room and in the PICU. And doing things that they believed were in her best
The seventh
interest.
floor covenant
Dr.
did believe her.
Elliott explained he was doing things pharmaceutically with her that he believed if he put her out the door because the parents wanted her out the door, it would be dangerous to her. Now, maybe he's right, maybe he's wrong. But for punitive damages, the first front end was it unreasonable and unwarranted not to send her home with mom. Keep in mind that mom's email, which is the email on October 12th, where she explains that she had this interview the day before with Dr. Smith. So she knows by then that Dr. Smith, by the way, is not one of our agents. But in that, she's explaining that she didn't want to take her home, that she was really trying to get her to go see Dr. Hanna, that she needed to have her in an ambulance to go see Dr. Hanna. So for a chunk of this time, she's not really false imprisoned, but one way or the other, the test is from an intentional misconduct, is whether we had actual knowledge of the wrongfulness of their conduct and the high probability that injury or damage to Maya Kowalski would result, and despite that knowledge, intentionally pursued the course of conduct resulting in injury or damage to Maya Kowalski. Now, there is no evidence that the doctors in the emergency room or in the PICU fit that standard. You heard from all of them, they don't fit that standard, without even getting to the fact that the level of management above this and knows about this front end, from the evidence at least, they're relying upon the fact that these doctors are on committees for the hospital for management. They're entitled to a directed verdict on this one. It's the same as to the EEG room and as to the photographs at the end when you look through those things. Under the evidence and the law on this, they're entitled to a directed verdict. Now, I've got a reserved motion for directed verdict on the issue of specific intent And I'm hoping that I'll try to do that in the damages part so I don't run completely out of time here. Thank you.
From the plaintiffs.
Thank you.
Well, Mr. Elegant.
You would like me to start with?
I think the one that Mr. Altenburn was hitting the most is that the conduct that was discussed at trial did not rise to intentional infliction of emotional distress relative to the Beata Kowalski suicide.
Okay.
Yeah.
Let's start with that.
I mean, I don't think you need to go to the wrong standard. That issue,
You've ruled on that.
Addressed and ruled on.
You gave them two different options. Okay.
Well, I think Mr. Altenburn first wanted me to come to the conclusion that the hospital had to specifically intend to cause Beata Kowalski to commit suicide. I think that is where I think Mr. Altenburn wants me to go. That particular issue, I don't think we need to address. But his next argument about the quality of the evidence is insufficient.
Okay, it is sufficient. And
how so?
What you heard is talk about one little thing here, one little thing here. Pages 2 to 5 of our response, we list many, many things that the hospital, using that generically for a moment, did over time to Maya Kowalski and her family, and of course that impacted Beata Kowalski. We do not say that there was not one event that caused the suicide. I don't think we say that. If there was one event, and we do think it was a series of things. There were a series of things that led to this. The one event might be the photo taking. And if you look, they make a statement in their memo, and I'm not sure we corrected this, that Beata didn't know about the January 6th photo session. Well, that's contrary to Jack Kowalski's testimony on October 3rd at page 138. He says he told her about the videotaping, told her about the photos. So he testifies to that. That's in the record, and the jury's, we get to assume that the jury believed that. Okay, so she was told about that. We're talking here about the mental and physical torture of a 10-year-old girl for 3 months. This goes on over a long period of time. To say, oh, well, the doctors, when she first came in, they weren't doing anything bad. Risk management was involved from day one. You can see that in the medical records. Risk management, as Beatty testified, instructed her to do these things, instructed her to videotape, instructed her to take the pictures, okay? And we have a detailed discussion in our memo about...
The videotaping and the pictures occurred after the first week in the first claim of false imprisonment.
Right, but during that first week, it's not just a few doctors at the beginning. The risk management is involved from the beginning in this case. As I said, we list the events that went on. It was, as you laid out, 3 periods of time. It stayed to that. I'm not going to try to go through all those things. They're in the memo. We've addressed them. And when risk management is involved, that is the hospital. Okay, I know they want to say we staffed it with lower level people, but in evidence,
trust me, guys, he's not nervous. This man is a pro.
There is a chart of the makeup of the hospital. This is in the record. We've got some extra copies of it.
He has been doing this for many years in the appellate court. He's a legend.
Above risk management, above that is senior counsel Crane. Okay, so risk management is under the auspices or reports to Crane. Right above her, she then goes directly to the chief executive officer of the hospital. Okay, So as we point out in it's about a 5-page discussion in the memo, Florida law and federal law and the Joint Commission that they voluntarily agreed to require that the hospital be responsible for everything that happens there. Everything. Okay? We're not talking about just supervision. We're not talking about just training. They're responsible for it. It goes up the line. Okay? And this chart shows how they were reporting up the line. So they are charged with the knowledge of that. That committee, risk management, under the senior counsel Crane, is directing these things be done. Picture taking, videotaping. They could have brought her in to testify. Oh no, that didn't happen. They were rogue. They didn't do that. And quite frankly, even if they had done that, they're still responsible. If you work through the analysis there, they are responsible for what happened. So if they weren't doing what they were supposed to do in terms of letting people know what was going on, that's liability of the hospital. And when we get to the punitive damage part, that is, they're either under A and B for approving, ratifying, etc., or they're under C for the gross negligence and not knowing what's going on. So either way, they're going to be liable there. And it sounded to me like the intentional infliction was blending over a little bit into the punitive damages. But if for either one of those, the hospital and the higher up people either knew or they are deemed to know under the law. So the intentional infliction, the items that went on, we say were sufficient. You've ruled that before. The jury obviously found it sufficient. We don't think this is a matter of law to be removed from what the jury did. If there are any other questions on that,
It's not. It's a matter of fact.
On the billing fraud, they listed hundreds of times that they were billing for CRPS. I still don't know that I've ever heard them say, yes, we acknowledge she had CRPS. I don't know that they ever said that, did they? I mean, I know you asked them about it. I don't know that you ever got a direct answer to that. They seem to want to walk the line on that. When you bill for something that you're not doing, that's fraud. Now, did it cause any damage? Did it cause any damage? That's why, in the closing, the request for nominal damages, because of all the other things going on here, there could have been a person who would come in and testify about this, this was too much, this would have been that much. They didn't put one on either. Okay, so that's why we suggest that a nominal damage is appropriate there. Let me flip back. One thing I forgot to mention, and I even had it tabbed, that the jury did hear. We talk about where's the evidence that they and again, we don't think they had to intend the suicide, as you real, but where's the evidence that they were so callous and so forth? How about Trial Exhibit 2175-004 from the text messages of Dr. Voss? Learned today that ketamine girl's mom committed suicide yesterday. Sorry to say my prediction was correct. You have a medical staff member predicting the death of a mother of a patient there. And why didn't they do something about it? Okay. Does the court have any other questions on anything else on the DV?
No.
Okay. Then I think I'm done. If anybody wants, you have access to this chart, I know, but if you...
It's in the file.
Yes, I know. Thank you, Your Honor.
Any very brief response, Mr. Altenberg?
First of all, with respect to Mr. Elliott, I think he must be confusing what Mr. Kowalski could have said about the videotaping in mid-October with what happened on January 6th. There was no evidence. It was very clear at the end of this case that she had no knowledge of the photographs that were taken the day before she committed suicide. Maya didn't talk to anyone about them, and they were back in a storage closet still in the camera at that point in time. There's no knowledge of that. As to Dr. Voss, we've been through this. You heard her testimony. This is, first of all, it itself is not extreme and outrageous conduct. It's after she's dead, and it's a text message type discussion between two doctors, and she has explained, there's nothing that she she reported or put in the medical records about this. The medical records show that mom was suicidal or expressed that she wanted to go to heaven, I think, that day, or maybe that Maya did, and that the people at the hospital offered to help her with
No, they
assistance to
didn't.
get help from someone else, which she
They didn't
declined.
tell anybody.
That's all that's in those records. And
Bullshit.
as Dr. Voss explained, she was saying prediction was maybe a bad choice, but what she was saying that she had thought about this because she knew
It was
about
not
something
reported.
like this 20 years before when she was a resident. Respectfully, I've never thought that that was relevant to much of anything, and the prejudicial effect of it is far more out there than the probative value of it as to that particular claim. As far as the things at the beginning of their response,
Then you
I
should
invite
have
to
put
go
the
through
motion
those and take a
during
look
the
at
trial,
negligent
not
things,
now.
How many are things that you can look at and
Right.
say are not accurate parts of the record?
They
don't
were
support
waiting
it
for the
any more than
verdicts,
the ones
Nick,
they specifically used
in
when they were
case they
addressing
won.
the particular one. There's no evidence on that in this case. Now,
I'm sorry.
go ahead. I'm sorry.
Yeah, were you finished with your rebuttal? Because we're then going to move to the next topic, and I'm assuming you're...
He's done hearing.
Okay. So what we're going to do is we're going to do the next topic, which is the motion for new trial, which is exclusive of the alleged juror misconduct issue. After we do that, we will take a morning break.
Good.
Well, I can't wait for the break
So,
because
Mr.
Brad
Alden,
has
you have the floor.
found
And I'll
the
try to be
agenda for
shorter on
today's
this one. I
hearing.
want to save a little
We
more
got to
time
go
for
over
the
it.
damages part because it's complicated. But on the motions for new trial, obviously on intentional infliction of emotional distress causing suicide, my argument would be if you saw some tiny amount of that, there's still the manifest weight when you analyze what the law should be on this is that verdict was just off kilter. The fact that it's off kilter on damages on practically every line kind of demonstrates that this jury was involved with a prejudicial effect and various things that got them to go off from the evidence. And so a manifest weight analysis, even if you didn't think it was a directed verdict, would stand on that particular count. I think it also would stand on some of the other counts, and I've argued those to you as well, but I'm not going to take time here today to argue those as well. Certainly, the insurance count, I just don't think there's any evidence there to prove that there was any, the nominal damages were not an element in that, and they needed to prove detriment to the insurance company and financially. They never did that. They never brought in anyone to show that that number had any impact on that. So that, if not the directed verdict, ought to be manifest weight. Now, we also moved for new trial because of the Chapter 39 issues, and I do believe that that is important. We wanted a broader immunity, and that was resolved on sovereign immunity, on summary judgment ahead of time. So I can't really re-argue that we couldn't get the broader immunity, but I will be arguing that later on in a different court. But here, there was a litigation immunity for things that went on in the DCF proceeding that kept out testimony about that. But it got to the point where we couldn't talk about ramifications of that proceeding. I mean, this woman committed suicide right after a hearing, and we couldn't really go into the details of that hearing or the fact that she's upset about having a hearing a month from now that she may lose her child to foster care, it may impact her license, the whole 9 yards. None of those things could we really get into as to the stresses that were on her.
Well, but let me ask you this.
You wanted the immunity.
In the years leading up to the trial, the defense kept saying Chapter 39 immunity, can't. But then at trial, the defense tried to present a lot of stuff that happened in
They sure as fuck
the
did.
dependency action. I mean, that's what the defense tried to do.
Yes.
So, I mean, I'm trying to understand, it seems like I'm supposed to exclude everything that the hospital wants excluded from the dependency action, but then allow the stuff that from the same dependency action that the hospital wants to use. I mean, how am I supposed to draw that line? And I think I kept talking about, this is where I've been drawing the line.
I know,
And that line I tried to draw as clearly as I could, but knowing the facts in this case were difficult, I admit.
The line is that no one could rely upon testimony on anybody's part to make someone responsible for something or the like. This is not going to be evidence that could be used to prove liability. What we were trying to explain, and repeatedly, is that but on what's going on in Beata's head, why she is upset, why she is truly upset, it's not because of the testimony in there, but the fact that it's ongoing and that they're accusing her of Munchausen's in the proceeding by the state, and the state is accusing her of medical child abuse.
Brad.
And she has hearing after hearing there. She's got lawyers there. All of this is going on. And, you know, she wants to see her daughter in the courtroom, and they basically have some understanding of that. But when we're on this, who caused her suicide? I'm
you
sorry,
did.
but
J-Hatch did.
It was really hard. You know, it's nice to have a jury instruction that says we're not responsible for 100 days, but to try to get the jury to understand all the 100 days of things that are going on unrelated to the hospital that were related to the DCF proceeding. That's what we couldn't get into. And, you know, I know in your head you were having a hard time on that distinction, but those were things we should have been able to talk about, because those were things that were really getting her very, very upset. Those were things that show up in her suicide note.
If not for J-Hatch, there would be no CBF, whatever they are
We're not
called.
allowed to do that.
Nope.
And that, to me, is a
Everything
very important thing.
Is because
With limited time
J-Hatch
here, let me move on
took
to
the
two other
decision.
things. The next one
It's because of these people.
is that
Yeah.
with Dr. Smith on the medical negligence. You know, the issue is whether she's an apparent agent. And again,
She
we have
was.
the
She was
email
wearing your
from
clothes.
Beata
Have a
Kowalski
permanent
to
office
herself.
in the building.
It looks like it was going to go to Dr. Hannah, but it never did. It went to her and to her husband. That clearly explains that she understands exactly who this woman is by the 11th of October. Now, apparent agency is not that complicated. It's a doctrine that says if Joe is negligent and harms me, and I let Joe do something that harmed me because I thought he worked for Chris's Lawn Care, then Chris's Lawn Care is on the hook if they're the ones that allowed that to take place. It's that he's not a real agent, but the plaintiff relied upon that person and I got hurt. That's the theory. That's the theory when it's the x-ray room that is in the hospital that looks like it's part of the hospital, but it isn't. Now, Dr. Smith came to the hospital, but before that very first day was over, she knew full well that she was there as a CPT person. Now, they're trying to say, well, she can be the CPT person and she can be your agent all at the same time. But, I mean, that makes no sense here. And what they were allowed to do was they did this and they did that became Dr. Smith in all of her capacities along with the hospital, and we weren't allowed to show even the report that Dr. Smith gave to the court and made available in the hospital on these things. But the evidence had to be that Dr. Smith did something that was treatment that harmed this child. And she may have impacted by convincing DCF to file the proceeding, but, well, she wanted to take the girl off drugs. Well, everybody did. Did that do her any harm other than ketamine? No.
Ketamine.
She wanted to take out a port, which Beata wouldn't let us take out. I mean, there's no evidence, A, that after October 11th that she was in any way an apparent agent, and B, there's no evidence that she did anything that was negligently harmful from that point forward. So other than advising us to call the hotline, she didn't do anything more than that. So I don't really
She removed her
understand
from her
how we got to
medication.
this point, and from the way the jury reacted, it clearly impacted them on the medical negligence claim because they interphased the two proceedings, the CPT proceeding and our proceeding. And finally, on count 14C,
I'm going to start timing them.
negligent
He's only
training.
supposed to have 15 minutes, and this feels like it's gone on for an hour.
should have come out before trial.
We had
Should have
45
come out
minutes
at
for the
end of
previous
case.
topic, and it seemed like
At the-
that only
excuse me,
took
at the
like
end of
20.
the plaintiff's case. But what happened, they dropped it down to negligent training,
I'm going to start timing it.
which is not a part of the medical malpractice case. And I told you that that evidence could, there could be some evidence marginally relevant to punitive damages, which I think is true. I don't think there was much of any there, though, because the punitive damages were for not letting, perhaps not processing an against medical advice request to leave the hospital properly. Maybe they weren't adequately trained on that. Dr. Corcoran didn't say a word about that. He didn't have experience in that. Maybe it was because when the doctor sought permission to take the videotape in the EEG room that the little girl would know nothing about, that maybe there was a better process to do that. Maybe there should be more training on that, but that's not what he testified about. What he testified about was the whole structure of the hospital was wrong. Well, that wasn't relative to anything that was alleged in medical negligence. It wasn't relevant to the training, I don't think, but it became a big feature of this trial right down to the end when we had all the problems at the end of this case. So the fact that 14C went to trial ended up being very harmful in this case and would warrant a new trial. The last
Harmful
thing
to
I'm going
who?
to mention is
J-Adge?
I do believe that Dr. Neuberger was allowed to say things that were very harmful in many of these claims. He was a child abuse expert, and he was allowed to talk about conspiracies and the like. We did object to that. You overruled the objection. And their argument is that we waived it because we didn't object again. I'm sorry, you don't have to keep objecting over and over again. We did object, you ruled on it. They then made the decision to play that video to the jury, knowing that if you were wrong in that ruling, that it was going to be prejudicial. They did that, and we're not in a spot where we're obligated to do multiple objections, especially when you remember how hard it was to get anything done between 8:30 and 9:05 every single day. The more we had done that way, the grouchier you got, with due respect, Your Honor. So
There was more than one or two objections during the trial.
yeah. So that's what I have on new trial. Thank you.
Mr. Elegant.
Quiet.
Greg should be doing it.
Thank you, Your Honor.
No, it's all elegant
To
because
start off,
I don't know
guess we'll
why.
go in the order.
but it's all elegant.
Anything you want me to particularly address, please let me know as I'm going along.
Yes, sir.
I was told Elegant was doing this today.
Litigation immunity. And there was a
thought
statement about the
Anderson,
January
quote,
6th
recused
hearing.
himself
This is
because
what
he
did
was
it. Well,
implicated in it, but
January 6th was also the day of the photos. And maybe I wasn't clear before. The October 3, 2023 transcript of Jack Kowalski is what I'm referring to. I wasn't saying that he told Beata this in October of 2016. He tells her, did you tell Beata what we just talked about? When I say this, the photographs that had been taken of her, the video that had been taken of her. The witness, yes, I did. I did tell her. That's page 138 of that transcript. So we have direct evidence in the record that Beata did know of those photos. Okay. Your Honor, kind of like you said, they want to talk about some things in DCF, but not other things in the proceedings. We would have liked to talk once and we offered not to talk about DCF at all, you'll recall. We made a motion on that, and they didn't want that. Okay, so, because they wanted to hear about immunity. They wanted the jury to hear about immunity. Well, that's a litigation decision. But if we were going to talk about more of DCF stuff, we would talk about their involvement with DCF, how they basically prosecuted the case there. People from the hospital were involved doing that. You noted in your long order a question about good faith. The couple cases that you acknowledged you had to follow didn't even talk about good faith. Well, we would have said a lot of things about good faith if we were going to get into the DCF proceedings, but we didn't. It was stayed narrow. I think to come in now and say, oh, well, we didn't get to do everything we wanted is a little late.
Yep.
On that day, again, tying into the DCF, Beata sees her daughter in a wheelchair. This is a 10-year-old who, among other things, was forced to defecate on herself, treated horribly, they just downplay this. As we say at the beginning of our response, they just don't get it. They don't get how bad what they did to this little girl was, and for her mother to see it, and then to hear about it when she couldn't see it and couldn't even comfort her daughter. As far as Dr. Smith's negligence or apparent agency, it's a little bit moot or academic in one sense, because there's a question on the verdict form about medical malpractice from the other doctors, and that's answered yes also. So, but to stay with Dr. Smith for a minute, to say that she didn't have any involvement, I mean, here's a note from risk management file, trial exhibit 2277-068, about the videotaping, and Dr. Smith is all over it, Dr. Sally Smith. She's involved in this.
I don't understand why we're relitigating this entire thing.
The question
That's
of,
how
well,
it
maybe the
feels.
knew she was a DCF or whatever, Child Protective Services person. The malpractice wasn't on Beata, it was on Maya. Smith walked into Maya's room as an apparent agent of the hospital. So she's the one that saw this. As far as back to the negligent training, it is relevant. For the reasons we set forth and discussed at some length, the hospital is by law responsible for training and responsible for supervision.
There was also a question on the jury form.
We also think, for the reasons we set forth,
on the
it's not
verdict form, did Mr. Sally Smith act as an agent of the hospital? And the
Otherwise, I
jury
guess it's
said
break time.
yes.
Well, we're going to let Mr. Altenberg.
Oh, yes, sorry, didn't mean to preclude that. Sorry, thank you.
Mr. Altenberg, do you have a brief rebuttal on?
Just FYI, my sister's an
Jury trial
appellate
motion?
attorney. She has been right about all of these trials. She believes that the plaintiff's lawyers are way better.
There wasn't any proof that Maya knew that Ms. Kowalski knew
She's
anything at all
always
about
right.
Photographs taken
Just
on
saying.
January 6th.
Just because J Hatch has a bunch of money to spend
As
on
far
lawyers
as
doesn't mean they're the
Dr.
best.
Smith was involved in some things.
Right.
She was a CTP person. She was doing investigations. We had to cooperate with her. Yes, she was also interested in seeing what that video would do for her case. That didn't mean that she was treating as doing something that the Kowalskis wanted her to do because they thought she was an agent of the hospital.
Mr. Elliott
which
only
is what
talked for
apparent
5
agency
minutes.
is about. Now, we can be responsible for what we did that day, but it's not because Dr. Smith was interested in
The camera
doing
is
it. That's a
as
totally
focused on
separate
him as
issue.
his argument.
But it ended up becoming this thing that inflamed the medical negligence claim that the CTP person was also interested in seeing the video on that. So that is, if it was anything, that would have gone to false imprisonment, but that is not something that should have ever gone to the jury on a theory of apparent agency for medical negligence committed by Dr. Sally Smith at any point in time after October 11th. So with that,
And before we run on break, let me just ask, and maybe you can think about this over break. Has Maya Kowalski turned 18 yet?
Yes, Your Honor, she has.
Yes, she has.
So do we need to substitute her as the true party, and do I need to change the caption and all that good stuff?
I'll return this motion to substitute her, Your Honor.
Is there any?
I was going to bring that up in the final judgment. I don't think they need to go to probate court. She's an adult now. It just transforms it. This is going to be a judgment for her, one for Jackie.
If we get there.
And one for the estate PR. If the verdict's good, that's how it would look. It would actually be better to have 3 separate judgments.
So
Denied. Sit down.
both sides want me to go ahead and enter an order substituting Maya Kowalski as the party plaintiff for Jack Kowalski as the parent of Maya Kowalski. Okay. I'll do that either today or Monday. Okay, let's take a 15-minute break. I'll
Oh,
be
thank
back in
God.
15 minutes.
Thank God. All right, let's go over the super chats that we have missed because there are several.
Yay! And
All
you
right.
you should have a lot more. Just saying.
Mike Dorado says, I embarrassingly have spent a lot of time defending both you and Kurt on that Reddit thread. Thank you for covering this. Don't get sucked in, Mike. Reddit is a terrible place. It's a terrible place that makes you crazy. So be careful in there. Be careful. But I appreciate the sacrifice. I understand it. Julio, thanks for the super chat, says, let's pretend it was a man and ask if it's molestation. Yeah, that was one of the grossest arguments so far. It wasn't molestation. It was unwanted affection. What? Gross.
I've said this for weeks, months. Take the exact same circumstances, the exact same words from that double, yeah.
And yeah, make it a man. Like
make it a man. Make it. What's his face? A case I covered not that long ago. Mr. Dinkins, who known child predator. I mean, put the same word in that guy's mouth and tell me it's not SA.
Yeah, I just wanted to comfort her. I thought she needed comfort.
Okay. Come here. Some hugs and kisses. I mean, just.
Oh, look who it is. Look who it is. Hello, Mo.
Hey, Mo.
I'll receive. What? So,
How's it going,
did
Mo?
we find Hitler? I'm confused. Did we?
No, we got a
Did we
Kiss
figure
album.
out if he's part of? Is he part of the Sixth Reich? Like, are we confused now?
No, it's even better.
I just need to know these things.
I don't know if we found him.
I was out yesterday. I was just making sure I
Willkommen
hadn't missed.
zum J-Hatch. Wir ist ein good hospital, yes?
Oh, Bex Fire, thanks for the super chat, says, gee, could it be that juror number one's wife used social media as an outlet for her feelings / opinions because she didn't discuss with hubby? You know, we've brought this up before. It's a very good point, and I think absolutely that's possible. Here for the Truth says, can we talk about the IJ? Where is it, sir? You produced it. And we may begin to trust what you're saying. Not, yeah, they're still fighting it. There's more stuff on the docket we haven't seen yet. Here for the Truth says, damn, autocorrect. Can't make a serious statement if it's messed up. Meant to say, if you produce the IJ. Yeah, I got it. But thanks for the second super chat. I'll take it. Southern Take says, they are forcing several more lawsuits. When the other ones win, they know they don't have juror number one to blame. This is about more than this case, in my opinion. I agree with that. This really is about the Kushner case that's still pending. They know they're going to lose big time, and they have to do everything they can, throw everything at the wall, hoping something will stick. So, yeah, that's it. All right. There's a meme on Locals that someone needs to explain to me because I don't understand it. It's funny. I'm laughing, but I don't know why I'm laughing. Hold on. Does anyone know what this meme is? It's funny, but I don't get it. It says it's right behind me, isn't it? Every time the defense lies to the court, and it's LawTube. But why the skeleton? I don't get it.
Because LawTube actually has a spine, maybe? Or...
Yeah.
Oh.
Every time the defense lies to the court. I mean, you have Megan, you had Rob, you had the other guys. I mean, every time the defense lied, the entire LawTube, you fucking liar.
Right. It's true. I mean, and they must hate that, which is why they go to Reddit, because Reddit is over there, stroking their ego. They're like,
oh my God, Daddy Shapiro, he's the best ever. Please, Daddy Shapiro, read my Reddit thread and put it in your motion.
And they never come over to where the normal people are, where, there's tens of thousands of us saying, you're going to get your clock cleaned, J-Hatch. You better watch out. They're not listening to that. They're over at Reddit because that's where they're getting licked, basically. Wait, did you guys hear? I think you were late, Nick and Mo. You didn't hear this, but there was a protest this morning, a Reddit protest. And how many people do you think showed up?
2.
Yeah, there was two. It was two.
I was going to say one but his mom drove him, so that was technically two.
It was two. It was two. And I think one of them was probably Keisa Shapiro. I think someone needs to get pictures so we can identify who these two were.
Oh.
I mean, were they also bus stop people? I mean, technically,
No. They were the
Redditors
wives.
also bus stop?
We were told they were the wives of doctors. So they're very wealthy, probably white women with nothing better to do than defend a hospital that tortures kids.
Okay, but why are wives of doctors more important than wives of a juror? Why are they held to different standards? I'm confused. Are wives?
It's the kind of wives that wants doctors discount because they're married to the doctor.
Wait, can I get discounts?
It's like army wives. It's army wives that believes their husband ranks
transferred
is about them too.
All right, so Brad
officer wives. I know what you're talking about. Okay, yeah.
No, not just officer wives. It's NCOs too.
Yeah.
Brad found something very helpful on the docket. Let's go over it, shall we? We have the agenda for the hearing today. It's right here. So let me zoom in so you guys can see it. During the December 15th hearing, the court anticipates that it will call the following topics in the following order. The court does not anticipate a ruling from the bench and likely will take all matters under advisement for later disposition. I figured he would do that. The court is aware that how it rules on certain motions may moot other motions. However, all motions will be argued during the December 15th hearing and the parties shall be prepared accordingly. Oh, I forgot to tell you the funny part. So up here, here's the funny part. The court has been notified that a media outlet will broadcast this hearing live over the internet using their equipment. Therefore, there is no need for the court to entertain the various requests to the court's public information officer has received for permission to broadcast the court Zoom webinar feed. That was me. I was one of those people bothering the public information officer.
The funny thing is, I was about to pull up the Zoom for that, and there's a line in there, like Rule 5 or something, that says that you cannot record or retransmit the Zoom feed.
Right, I know. That's why I called the court, and I said, I asked them, I said, look, if we're not going to have a pool camera there, the public interest is so great that you really should lift the ban on rebroadcasting the Zoom feed. It's not like other courts don't do this. They do. They broadcast their Zoom feed all the time. And she goes, oh no, we're not going to do that. And I said, well, I would like to file a motion asking for it. Because if we're not going to have a pool camera, I think that there's an argument to be made for the rebroadcasting. So
and also it's about jurisdiction, and they don't have jurisdiction outside of the state.
Yeah, right. So that's also
not
true.
Legal advice.
However, I mean, technically, like you're right. A person could disregard that order out of the state and just rebroadcast it and take the chances. And there really isn't much that a court in another state can do to you. However, what they might do is shut down the whole thing.
Yeah.
And in that's probably where they would go with that. They would put a password on it. They would take it down from the public. But then again, that would be like a really draconian thing to do.
In
But
Biden's
anyway,
economy, I can't afford legal representation for that.
It ended up being no big deal because Law and Crime decided to go and put a camera in the courtroom. Now they only allowed one camera this time, not several cameras, which is why we have this this weird back view. All right, the parties shall have their professional calendar with them in the event the court needs to schedule further hearings, which likely would occur somewhere in the week of January 2. Topic of alleged juror misconduct is first, so we already heard that argument, which didn't go very long at all. Number 2 is the topic of renewed motion for trial. We heard that. A total of 15 minutes per side was given for that. No, it's interesting they gave 20 minutes per side for the alleged juror misconduct. Number 3, topic of motion for new trial, exclusive of juror issue, a total of 15 minutes per side. Number 4, topic of motion for remitter. I think that's next. I think we didn't get to that yet. A total of 15 minutes per side. Then there's the topic of motion for entry of final judgment, a total of 15 minutes per side. Now we have that final judgment motion. We can go over it in a minute. It's basically, here's all the money that you owe. Pay up, J Hatch. Show us the money.
They're
So
like,
that's
will you
hilarious.
accept Walmart gift cards? We have these IOU. Will you accept like for future visits? You won't have to pay.
Melanie, no, RA does not have his cameras in the court. He is pulling from the pool feed. He's not, no
Oh.
one is allowed to have other cameras in the court besides the one pool camera that is allowed. And then what happens is any of the pool reporters can access the law and crime feed and put it onto their stations. And that's what he did. He is in the courtroom, but he's not able to have a camera inside the courtroom. So he's using law and crime's camera. Otherwise, that wouldn't make any sense. They don't allow other cameras. They allow one. That's what the point of the pool. That's why it's called a pool camera. They have one camera that all news stations and people pull from in the courtroom. All right. I'm sure he brought his equipment, Melanie. He means his streaming equipment and his computer and stuff. He doesn't mean a camera.
Can we petition Recovery Addict to come to both Megan's house and my house and set up our stuff like as charity?
You have no idea. You have no idea how much I bother him. And he's so sweet to answer my stupid questions about my technology.
Y'all, it's out of the box, and I think I set it up. But
God,
do I understand how to use it? No, I think I set up the buttony things. But then I'm like, what is a folder and why do I need it? And how does this work with anything else? And I was like, oh crap, I've lost the instruction booklet.
All right,
How do I
Mo,
look up the instruction
you need to
booklet?
get with me offline and we can get you set up.
Yeah,
That sounds. Thank you so much.
IT Goatee Brad to the rescue. He knows how to do it.
I
He
am
can do
so
it in
sorry
like
for your
a few
moniker.
minutes. It is your fault. You know that, right?
It is. Yeah. Well, yeah.
Oh, wait.
I'm looking at
Recovery Addict. Hold on.
I'm looking
Hold
at his
on.
page and I can see he's live.
Here, wait.
These are here. Joe's here. I'm here. Everything connected. The system is running. I just.
Oops.
I don't think I've ever seen his face because he's usually like you can see his screens.
I know.
Also on Top Mark Media, my other channel. I apologize. It just in the last minute, it just couldn't get that final connection to work here. So, guys, thank you very much. Look forward to having a great day. We'll see you.
All right, we'll hear what else he had to say. We'll back up and hear that. I think he was just giving an update from the hallway, probably. Look at him all dressed up. What is the deal?
But we won't be able to forward it to the Recovery Addict channel.
I don't know what the deal is with my connection today, but I'm having serious
We're
problems.
having some trouble with that. But court's about to begin. The Kowalskis are here. The attorneys are here. Joe's here. I'm here. Everything connected. The signal's running.
Oh, this was this morning.
You'll have to watch it on Top Mark Media, my other channel. I apologize.
All right, that was this morning. I thought that they were replaying that from earlier. I thought it was live. All right, anyway, we're very grateful to Scott at Recovery Addict for being so generous and sharing his feed with us and giving us blanket permission to use it. And so we don't have to deal with Law and Cuck's logo. It's been great not to have to use the twat waffle today.
It is really nice.
Right?
Okay. But the one protester, did they have like their own sign? Did they glitter and puff paint it themselves? Or was it like one of those ones that you can tell it was?
Well, I'll tell you
it was printed.
I'll tell you what the information that I got. The information that I got was 2 protesters present, very well behaved. They said hello as I walked by and I reciprocated.
I am waiting for the magazine cutout Jesse Smollett letters to arrive. Like, just saying. I don't put anything past these people.
Okay, well, yeah, this I agree. What's so strange though to me is that I really can't understand who would take time out of their day to go and protest for $1 billion conglomerate against a family whose mom is dead, whose child was tortured by these people. And they even admitted to some of the stuff they did. They're like, okay, well, there's liability here, there's liability there, but maybe just not that much liability. Okay, well, we dropped her. We may have dropped her a few times.
There was a little dropping, but I mean, who hasn't dropped a kid once or twice?
I mean, that's how I feel. My reaction to that. Well, we might have dropped her a few times. There was some rough handling of a CRPS patient, but it's not worth $50 million. It's worth I don't know, 500,000. I mean, come on.
Look, it will bankrupt my husband. I've already spent his money this year.
Yeah, doctors' wives. They're just worried about their take-home pay. But this is all being paid for by insurance. Who are these people who are most of it? Who are these people? They're only going to lose that 50 million without the insurance. Who are these people who have so little to do in their lives that they're going to go to bat for a massive conglomerate that is absolutely not going to be harmed by this? They might be harmed by the next couple that are coming their way, but I don't think they're going to be harmed by the 50 million from this one. And anyway, they should be harmed, because what they did was terrible. What they did was bullshit. And it was very wrong.
Wrong.
Yeah. All right. The topic of number 5 is going to be we said final judgment. Then number 6 is going to be the sanctions motion. So we just discovered that sanctions is actually going to be discussed today, but they're only getting 10 minutes per
using a more
side.
generic concept of the damages problems in this case, because remittitor is the last in the area where I at least don't hope you actually have to go, because I don't actually think that these numbers allow you to do a remittitor. If you thought you could, but these numbers are so far off the mark that I don't think they line up with what a judge can do with
He's
remittitor.
only supposed to have
But
15
what I'd like to
minutes.
discuss is the methodology of the per hour, per element, or component of damages, and the errors in relating to that, first as to Maya's claim and as to the wrongful death claim, and then finally the damages as to punitive damages. Now, you know that we filed in advance motions to try to prevent him from doing his
a lawyer is trying to argue math
per component approach to this. And you denied anything other than my ability to see the numbers. And when I saw the numbers, I explained to you before closing argument that they were much higher than the range in which a jury was free to operate, and that he was going to use this PowerPoint that was going to have numbers that between the two claims totaled $200 million, and he was going to use them as totals to this jury, and that you should stop that. And that it was wrong both because it was an artifice, but because it was false statements of law, because damages are supposed to be done claim by claim by claim. And you basically said you were going to go allow him to do his argument, but that he did it at his own risk. And he did exactly what I told you he was going to do. He used these numbers to put forth things that are not only beyond the range in which a jury is free to operate, they, especially as to Maya's claim, were misrepresentations of what they were supposed to do. And in that context, there were things that in fact he did not prove at all. So I continue to believe that the use of these was something that should have been prohibited, and that they warrant not only a new trial on damages, I think they inflame things enough that would warrant a new trial on everything, but categorically they would be, this is something that he did that demonstrates a need for a new trial on any claim that damages were awarded on. Now, as to Maya's claim, the impact on this is interesting. Now, let me first start with the economic, because the economic is basically past medicals is the big issue. And I point out in the motion that they never actually proved any past medicals. The PowerPoint and all of this didn't ask for past medicals to Jack Kowalski. and yet the jury gave him, between false imprisonment and battery, a combined total of $1,513,498 in past medicals, when even the 3 years of bills from the family for everything that the family had to Aetna was substantially less than that, and those bills really aren't related to anything. You've had a lot of personal injury cases. You know that if there is a medical treatment for a battery or for a false imprisonment, you need a doctor to say, I treated for this, my treatment was reasonable and it was necessary and my bills are reasonable. You got to have some version of that. And yet there was no evidence of that at all for any of the false imprisonment or for the battery. And there was no claim, by the way, at all in medical malpractice for past medicals. They didn't put in evidence or make a claim that the medicals in the hospital were something that were be recoverable under medical malpractice. So there was no claim there at all. So not only they did not ask for it in the PowerPoint, there was no claim in the medicals, and there was no proof for those in the record. But what he did was he put his large numbers up and basically just tells the jury, this is how much I want in total, and just kind of go in and fill the blanks in some fashion. So he is complaining, by the way,
Did you object?
That, well, I didn't make recommendations as to specific numbers. He didn't do specific numbers at all for the Maya Kowalski claim. He just put this stuff up and said, I want it all, just give it to me somehow. The problem is that he never proved his economic past damages. The amount he proved was 0 for that. And that is what that amount should be on the verdict form if the jury was following the law. Now, as to the economic damages, then we have, the non-economic damages for Maya. These, he uses this approach of having her have human damages for this component and that component by hours per day. For every day of her life, for the rest of her life, she will have these damages. And he puts together these numbers that are $107 million for all of the torts involved, the intentional infliction, the false imprisonment, the battery, and the like. It's going to be almost $8 million, which is a number, you heard the evidence. There's certainly some value to those claims, but it's nothing remotely close to what any jury in Sarasota County or any county in Florida has ever returned for the things that you heard as the evidence in this. I told you they would be a magnitude higher. I think they're actually more than a magnitude higher than what happened here. And yet the jury came back with the numbers that I described in the motion that are sky high for all of those things for Maya. And they are clearly excessive, and it was brought on by the argument. Now, as to the wrongful death, it's a tiny bit different, because in there, at least, they are broken down in the PowerPoint. And on that one, I mean, by dividing the pain and suffering concept into components, and once again, using hours a day. By the way, Maya in particular, is having pain and suffering for 15 hours a day for one claim and 12 hours a day for the other claim. I guess they're happening simultaneously as pain and suffering is tacked on one another under this theory. But he ends up with Jack Kowalski having a claim for $26 million, which is more than practically, I don't know of any medical malpractice, any wrongful death claim in Florida approved by an appellate court where a husband got $26 million. The highest numbers I've seen are $15 to $20 million. And yet he's getting this, and the jury, this basically doubles it, gives him $50 million. Because they got $200 million to spend and they're trying to figure out where to plug it in is what they did.
What if I agreed with you that the wrongful death component for Mr. Jack Kowalski was too much? How does that work? What if I granted remitted as to that claim, and then let's say the plaintiffs disagree? Are we retrying the entire case, or are we just retrying that one claim?
The law on this is that I can argue that I was entitled to a new trial on this. And once that is denied, then you go on to remittitor. So I don't necessarily have to accept a remittitor myself, and I can challenge the denial of the new trial. So I have made all of these arguments, but the notion that...
Well, and I agree that we start off with new trial, juror misconduct, and then we work backwards. And if we end at the beginning, then we're doing a new trial. If we get farther down the road, then it depends on where we are. I get that.
So,
but if I'm for the sake of argument, and just for the sake of argument, this is obviously not a ruling. If we're in this space where I'm talking about remittitor and having denied everything upstream.
Correct.
So how does that work if I grant the remittitor relative to wrongful death as to the survivor, Jack Kowalski?
Very generally, I think the jury is in, it's easier to do, by the way, with economic than non-economic, number one. But with this, the jury was in the range, and I'm going to adjust it by downwards by 20%, or sometimes upwards by 20 or 30%. Judges will do, because you can do it either direction. And you could do it here, but it's $50 million. You'd have to drop.
What happened to the sound?
$1 million off this thing.
I no idea.
A reasonable range for
It just
it
disappeared.
$15 million.
It's the court feed.
Well, what the hell?
Oh.
Well, theoretically, you can do this. The law also says you're not supposed to become the sole juror or
the
seventh
PowerPoint
juror making these
is
decisions,
evil,
because these
is what I'm
numbers are so
getting
far off the
from
mark.
this.
Well, they generally are. But...
If you deny everything else,
Well, I mean, I have
I gotta
often
tell you,
said that
I don't actually
PowerPoint should be
think
added
this
to the
case
Geneva
fits the
Convention,
scenario
but
of a remitter because of that.
no one seems to listen to me.
Well, I need you to assume that I've denied everything upstream, and we are talking remittitor.
Right.
So
And I've
I
given
want to try to
numbers.
focus on that.
Yeah, and I've given numbers in my motion as to numbers that I think you should use for that. And I don't have them memorized, so I'm not going to give them to you. But you would have to come up with what you think was essentially the maximum legal range in which the jury was free to operate in awarding these amounts.
And then mechanically, how
does
that work?
You sit down and use the, there's no scientific method for you to do this. You just make up a number, Judge. That's the problem with remitters, is that they reach a point where it's not a judicially normally based decision process. But if you do it, you're just going to have to say, well, maybe I've watched Sarasota County cases in wrongful death. I've got a sense that husbands normally get $7 to $8 million in a case like this, and that I'm going to stick with that range because that's the appropriate range for this case. That's how you would do that in this kind of case.
And then assume I did that, and I'm not saying the number, but
yeah,
assume I did that. Then the plaintiffs would have the option of accepting or rejecting.
Yes.
If they reject,
then
are we retrying just that damage claim, or are we retrying the entire case?
If you were convinced that this didn't show damage, that it didn't impact everything, and you rejected all the other motions that I've made, we would only be retrying damages at that point in time.
As to that claim and not the other claims.
Claim and not to other claims. And you're right, it gets really complicated here because there are different claims that would have different outcomes on that. But it's not inconceivable that among all of these there would be something where you could decide that a remitter was appropriate, they could reject it, and you would have to have a new trial only on damages to that. I'm just not conceding that is generally how that would approach in this particular case. Now, if I can shift to the punitive damages.
Sure.
The damages on the punitive claim are $50 million. And you know what the evidence is as to these things. On the first week, we kept her. Girl was sent to us because the doctor thought she needed to be in our emergency room. We concluded he was right, and we kept her there for a week. And we kept her in the pediatric intensive care unit. Now, there may have been medical negligence and other things, but as to false imprisonment, that's what we did. And we did it.
We did it.
Because I think we felt that it was the morally correct thing to do, and at least
that is what we falsely imprisoned her. Yep, we did.
As well. But when you look
I'm not going to
at
listen to
the
them talk about
elements
morality.
in the final verdict form, it's, well, did we do this because we were solely motivated by an unreasonable financial gain desire? There's no evidence of that, and there's no reason to think that this one or any one of these things was done for financial gain. Was it unreasonably dangerous nature of the conduct together with the high likelihood of injury resulting from the conduct, and was actually known by the managing agent or other person responsible for making decisions on behalf of the hospital? Well, was it truly unreasonably dangerous? Was there a high likelihood of injury to Maya because we kept her in a pediatric intensive care unit?
You dropped her!
Was there such when we moved her down the hall and surreptitiously videotaped her, which is not actually an element of false imprisonment? We
You
just
made
moved
her
into another
crap
room.
herself.
Now, we have to accept the evidence. She says that she
Wait,
defecated us.
videotaping
I
her
don't
without
believe
her
that she said
knowledge
that
is
some nurse
not a
sat there and
part
watched her and
of
said, "I'm gonna wait till you
violation of her
defecate us."
rights
She claims she defecated.
for
Now,
reasons.
you can go through, if you want to, because they say they're not in evidence, but every single one of those clips is in evidence. We only, between the two of us, I think we played maybe
He's relitigating
5 or
this whole
7 of
thing.
those clips to the jury to demonstrate that it's,
The people have
Hasn't it been 10
spoken,
minutes?
Mr. Burns.
is a room like any other hospital room, and she's got a commode next to her bed like she did at her other one, and that she's getting PT, and there's a nurse in the room and the like. So whatever that is, you have to accept the facts as they are. But that is something that warrants us to have punishment of.
Can't you do Mitch McConnell and just glitch out for a while?
Multiple millions of dollars because we didn't kept her in a pediatric intensive care unit, because we moved her down the hall into a room.
We
and
dropped her on the way.
Supposedly
Deny,
her
sit
different by what
down.
she describes, and then finally for the photographs that we took. Now the
We
photographs
are
we
at
took, because
14 minutes and
once
50
we
seconds.
started back up
He is supposed to only have 15
at
minutes.
that point in time with
5
Deanna
seconds
having
until 15
Facebook
minutes.
time,
5 seconds.
the next day she
And
has
it's 15.
cuts on her body, and Dr. Elliott reported that he thought she was self-inflicted.
15:05.
The record shows risk management knows that we're
Come
worried
on, Your
that-
Honor.
that she's now self-inflicting.
You
and
threw
mom's talking
Jesus
to
in
her,
a dumpster.
And they wanted those pictures taken before and after she went.
Craig and Whitney are going to let him go on and ramble.
The lesions are symptomatic of CRPS, and so don't I need to assume that those lesions are...
We know, Madeline. We can't fix it.
What you have to assume for this case, for this part of it, and maybe he was negligent in that.
He's getting forceful now.
If he comes back in here today, he's going to tell you those aren't CRPS lesions. That's what he believed, and that's what he told the jury.
Jeff
he
says
believed.
hi.
And so maybe that's a negligent misdiagnosis, but was that something that was done at the level of intentional misconduct for punitive damages? So on all of these things, when you compare what we did to the tests, these numbers are multiple times higher than they should be.
Should I also consider the evidence that was presented that the hospital did not believe Maya? I mean, how am I supposed to factor that, Mr. Altenberg?
Tuft of Justice speaks the truth.
It looks to me like a scratch, to be honest with you. I'm not a doctor, but I mean,
You
it's
aren't
not
a doctor,
necessarily
shut
that
up.
they disbelieve this little girl. I mean, she's there, they think in part for psychological reasons. It's not necessarily that she's doing things intentional in this situation. But I mean, you can factor that in, but if you do factor that in, that makes it $15 million or $10 million or $50 million for these things. That's an enormous amount of money for factors, for things that, for which there's no evidence that she got medical treatment before.
Your Honor, we
We've
know she's
suggested
going
that
to
she
use it
probably
all on
ought to have
bubblegums and
some
Pokemon
psychological
cards.
therapy that she's never had in this case. But whatever that is, these are not the kinds of things like, the tobacco companies get hit were $10 or $15 million, but they knowingly, intentionally hid from the fact that they were selling a product that was going to cause you an addiction that could lead to lung cancer. That's the evidence in those cases. They get high numbers because the facts are really pretty outstanding in those cases, and there's multiple people involved in that. So if you look at this the way it is, I submit to you that those numbers are far out of range for anything that's reasonable. Now, can we not file bankruptcy? Well, probably not. But the front end test is, does this conduct warrant how much money as a deterrent? And these numbers are sky high on that. And if
I'm just, because we're in a remitted or situation.
And you can do a remitted on this as well. Yes, you can. And
it's just your argument seems to be more of a new trial type argument as opposed to a remitter argument on this punitive damage, because I don't hear you saying that.
Well, the biggest reason I think there's a new trial, and it's this last part, is when we get to the claim about whether there was specific intent to harm her. They are correct, by the way, and I was mistaken at the
18
time
minutes
of trial.
and 39
I can
seconds.
be perhaps forgiven for the fact that I found
3
out they
minutes
wanted this
over.
in the morning, had to leave the courthouse, go back to my hotel room and try to research this and come back that day. But the standard jury instructions on this, if I can find this in the form, this is bracketed language, so it's optional bracketed language. And it says in comment 6, instruction 503.1C2C should be used only after the court has determined the evidence includes some additional circumstances that may affect the amount of the punitive damages. Well, the way for you to, because this, if you read the text of the statute, is not a measurement of damage. It's
just so I'm clear, are we talking about adding the question in phase 2?
Yes.
That actually was the proper way of doing it?
Well, I will tell you that the standard jury instruction puts that option in there. I'll tell you that the standard jury instruction is dead wrong, because it's not something that is used just to measure damages. It's something that lifts the cap. The jury never knows about the cap. This is something that takes you from having
Greg just threw his head back, and with his mouth open, he went like this.
It dramatically increases the ability to do it, but it also puts into the mind of the jury.
So now the instructions are wrong, not only the PowerPoints and the juror and the math, but the instructions.
You can't change that cap unless you have clear and convincing evidence of something.
I mean, isn't this really an academic discussion?
No, it's not, because
why not?
Because they were supposed to give me their jury instructions by mid-August. They didn't.
Yelling.
They never gave me that punitive damages instruction
Sir,
until
your
the
sassiness
morning
needs
it
to
was
be
going
cut
to
the
be
hell
used
off.
in the afternoon, and that was my first notice that anybody had any thought that this case involved specific intent crimes by my doctors.
Nick Whitney's
And I submit
eyes
to you
are
that
wide
there
as
is no
saucers right
evidence that
now.
anyone in the emergency room or the pediatric
It is
intensive
hilarious.
care unit had a specific intent to harm Maya Kowalski when they kept her there under their care. There was no
Haven't these
specific
jokers
intent to
still
harm her
not given
in
the,
other two areas
you know,
as well.
big,
But isn't the
y'all have never had a risk
not
management thing
exceeded
over?
in this particular case anyway? So isn't this really?
It's exceeded because all the other damages are
And they want to be
excessive.
upset that they weren't
And
given
because
something
you
that
put
time?
this thing twice on the verdict form for them to focus on, well, yeah, we should give them higher punitive damages because there's a specific intent. I submit to you there's no evidence of that, and I never got to make any predicate motions to have that stricken from a complaint or stricken from jury instructions. I never had an opportunity while there were witnesses there from management, because this is a management test of specific intent, not to be able to put on evidence about this.
Well, but assume I messed up. That would have been a mess up in the punitive damages portion.
Yep.
And Mr. Shapiro's argument seemed to be very persuasive to the jury. The fact that the jury awarded 10, 15, and 25 million only when there was evidence of what, $500 million of securities and free cash. So I'm just saying Mr. Shapiro's argument seemed very persuasive about every dollar you award Maya Kowalski or the family is a dollar that you can't give charitable care in Sarasota County, was the argument.
Okay, but when General Motors does a punitive damages thing that under the measurements of how you determine the amount is worth $3 million, the fact that General Motors has a gazillion dollars doesn't mean it's okay to transform it into $300 million. The money amount is there just to demonstrate that you cannot bankrupt them. But the fact that someone is rich or poor doesn't necessarily change the amount that's needed to deter other people in the future or to deter these people. I mean, this has deterred the hospital. They're going to be very careful about who they bring in and how long they let them stay in if they're in DCF custody. That's what's going to happen. We could have discharged this girl about the same day as the shelter order. If we'd let her go on AMA as they wanted, DCF would have filed it here in Sarasota County. The judge would have entered the same order. There'd have been a pickup, and she'd have been in Sarasota Memorial Hospital, and they would have been the hospital not giving her ketamine. That's all that would have changed.
Well, let's be clear, because when you say nothing else would have changed, are you suggesting that some other hospital would have battered Maya Kowalski? Are you suggesting another hospital would have falsely imprisoned her? Those are issues that had nothing, that did not flow from the DCF proceeding. So, I mean, that's what your argument seems to be.
No, my argument is on that for deterrent purposes, you've got our attention. It's just unfortunately it's going to have adverse effects on this. Because we don't think...
Greg Anderson is going to argue this one, guys. He's coming up next.
We're keeping her safe in the PQ. Admittedly, those photographs are not pretty, and maybe we should not have done that, but I do not believe that rose to the level of punitive conduct as compared to compensatory conduct.
Thank you, Mr. Altenberg. Who's going from the...
Mr. Anderson.
Based on the court's question at the start about the damages to Jack Kowalski based on the wrongful death, I have an answer for the court. If the court noted the jurors were all, from my view, and no offense to any of the female jurors there, between the ages of late 40s, maybe mid to late 40s, and into their 70s. I submit to the court that these folks know what it's like to grow older and the challenges that are ahead of them. Now, the court's familiar with the law, but there's a quote out of Hawk versus Seaboard Coastline I think is appropriate. Damage for mental pain and suffering is one of the late developments in the law, and its potentialities are not restricted as they formerly were, because so much has been learned of the evil consequences that flow from mental injury. And that's back in 1989. The reason I think that's of interest to the court is, please remember Dr. Brewerton's testimony, which I think was reiterated by another psychologist. He's a psychiatrist, that PTSD actually forms a lesion, a permanent physical injury to the brain, which was never going to change and never going to heal. Now, I would like you to keep that in mind with the idea that from the jury's perspective, now Jack Kowalski was faced with should have been the greatest part of his life, trying to get his kids along, but with a wife that loved to do the same things he did. They got along well until this. They had built a great life together. They were happy. They had it all. And then that's when all this stuff came in. So the jury then is looking at somebody who not only loses the ability to live out some of the best years of their lives, and he's not an old man by any means. He's in, I think, his late mid-50s. But my point here is, Judge, they understood the waking up in the middle of the night, wondering, who's going to take care of me as I get older and the kids are out on their own. Taking care of a daughter that has a very, very difficult disease to deal with, which is so uncertain, and having two kids with deep-seated now psychological problems. So his loss of Beata was based on a 2023 jury looking at what we pay now in this country, in this state, for different things. We'll drop, we'll drop $100 million to get a kid out of a hole.
I mean, I sat through the whole trial as well, but let's talk about the mechanics of remittitor as it relates to Jack Kowalski's wrongful death claim as a survivor. And
Yes,
if
sir.
the court were to grant a remittitor, how does that work as to that claim?
I hadn't researched it as closely as my appellate counsel could probably speak better to it, but I would understand.
I mean, I'm here, and that's the question that I've got.
All right. Honestly, it would be better to have Mr. Elliott.
Mr. Elliott, why don't you tag in? I know I'm violating the two.
Thank you, Your Honor. Of course, we don't think there should be a remittance.
I know,
But
I know.
I know.
But I'm having to deal with all sorts of.
Yes.
I mean, if we find that there was, a new trial necessary, we don't even get here.
Yeah.
It's.
I understand. I think what you heard before is essentially correct. You would remit to the highest number that you thought the evidence supported. The law is clear on that. We've said that in the memo. Then the plaintiff gets to elect. Do they take the remittitor, and then that goes, you enter a judgment with everything in it, or do they reject the remittitor and get a new trial? Assuming the plaintiff accepts the remittitor, you would enter a judgment. The defendant can still appeal that because they wanted a larger remittitor or they've got other issues.
Okay, so.
But then the retrial.
I gotta go. See you all.
It would
Bye,
be
Nick.
limited.
Thanks for stopping by.
Damages issued on wherever you remitted. You would not go back and try liability. You would not try any other issues.
Okay, well, that answers my specific question.
Yeah. Yeah, if the remittitor is rejected, or excuse me, if the remittitor is accepted, as I said before, there would be, whatever would be the judgment, we've submitted a form, and whether it's 1 or 3, it would be, you would enter it with that number in it. So there'd be a judgment entered, and that's, I know we're coming to that issue, but that's an issue because it's a large issue on interest. It's not accruing now, but will be once the judgment's entered. Is there, I don't know if you, I was going to respond to the punitive damage part. You had one more compensatory?
Questions, either one. Take your pick, right?
Mr. Elliott.
Okay.
He's standing there.
Your Honor, on the punitive damage issue, we have threshold issue is the same issue for compensatory and punitive, which is with a couple of exceptions, they didn't suggest any numbers to the jury, none. They suggested like one number on, actually if I could have that sheet. I know that's the one. Thank you, sorry. 272,000 they suggest under medical malpractice, and they didn't suggest any damages for any other categories. And then they suggested 500 to 1.5 for each plaintiff under the wrongful death count, no others. And, there's case law we've cited that says, well, if you don't give the jury anything to operate from, kind of hard to come in and say these are too much. I mean, they could have come in and said, it's well recognized that you can have the per day, per hours, just a variation of that, and there's cited a case where they've done it. But if they thought that was crazy, they should come in and say, those numbers are crazy, do this number. So as far as the punitive damage numbers specifically go, they keep wanting to focus on the physical. We weren't that bad to her physically. But they just want to eliminate the mental part of this, the mental effort to break Maya and break her family, and in particular her mother. That's what this was about in large part, and I think the jury got that. The results show they got that. And these all coalesce together. All these things, as far as the things for Maya, they did different things, but they all came together to cause the situation she has, the damages she has. And that's, to apportion those out, they could have suggested some other way to apportion. There's nothing wrong with apportioning it. Those are, if you have a typical situation, you have a one car, bam, accident, it's done, that's it right there. That's not what we have here. We have different things over a period of time. And we analogize it to the situation where you have, two injuries and one's caused by somebody else, and the instruction is, well, if you can't apportion it, then you give it all against the defendant. I mean, here, we didn't have to get to that because it was just one defendant. As far as them saying we didn't know this was coming, their memo at pages 41 to 45 complains that for a long while about Dr. Newberger's testimony. And he was talking about the intent and how bad their actions were and that they were intending to harm the family. They knew it was coming. That was there. And as we pointed out in our memo, and we argued this with regard to other things, you don't plead every nuance of the case and every little thing you're going to try to get to when you set out to plead the complaint. So we think that was covered. Do you have any other questions on it?
No, sir.
Oh.
No, sir.
Okay. Oh, well, I may have one more thing. Let's see. Oh, yeah. Well, I think you made this point, which is you've got $50 million. I mean, part of the test on the punitive damages is how it compares to the worth and will it deter it. And you have to have a larger number.
He's only been arguing him and Greg together for 8 minutes.
So that is appropriate.
He's ready to give it up already.
It is not. Thank you.
Then again, okay, so 8 minutes, 15 seconds
any brief rebuttal?
for the plaintiff, 25 minutes for the defense. But the length of your argument is not always, that doesn't make it better or worse.
I wrote the opinion, and we did make the
6 minutes of shouting.
The reason I filed the transcript yesterday to show my objections up front and what Mr. Shapiro did is that we did suggest numbers for one of the false imprisonments that we thought was important to do. We suggested a number for medical malpractice, and we suggested up to, I believe, $4 million for the wrongful death case. So we did put those numbers in there. The people who didn't put numbers in for Maya are the plaintiffs. They come and say, well, we can use this whole ball of spaghetti again and just tell them to throw it out however they want. Well, I'm sorry, but twice the jury instructions told them those cases are to be tried separately as if they had been tried all by themselves. And then on every single set of instructions, the standard instructions tell them to award damages for this claim and for the amount for this claim should be reasonable for this claim. And so for them to walk in here without any case law authority at all and say, oh, we can just say, oh, the total damages for these 5 torts are $1,007,000, and therefore you should just kind of fill in those lines any way you want to. That's not appropriate argument. But it was an artifice, it was a false statement of law, and that's what impacted this verdict. So we need to have a new trial because of that. On the specific intent, even if I'm wrong that they didn't need to plead specific intent, keep in mind all they pled was willful, wanton, malicious. We tried all of these punitive damages on the complaint that said willful, wanton, malicious. That's not too close to the target. But our understanding was, we actually got an extension on the jury instructions that we would work these out by the middle of August. And I gave all of the liability instructions and asked for damages instructions. And the day I got an instruction that says specific intent injuries to lift a cap on punitive damages was the last day of jury deliberations. That is not fair notice to me. And I would have done things dramatically different had I known that. Frankly, I wasn't in the courtroom when Dr. Newberger testified, and I didn't read that stuff till after trial.
Well, whose fault is that? You could have been there.
Thank you very much.
Now, so, Your Honor, we fucked up, and we didn't do what we were supposed to do during the trial, so we want to win.
It assumes that we get to the point of entering a judgment. No one should assume that a judgment is going to be entered, because I still have to deal with juror misconduct allegations, the motions for new trial, all the way down. So I understand that this is a more of a discussion as to mechanics, but let's talk a moment. Assume a judgment were to be entered. Is it a single judgment? Is it 3 judgments? Is it, what do we do about that whole discussion that Mr. Altenburn had with, I think it was Mr. Anderson, about the lien? So who wants to kind of talk first about those issues?
I'm happy to say that, I don't know whether it needs to be 1 piece of paper, 3 pieces of paper, but it is legally a judgment for Maya, legally a judgment for Jack, and legally a judgment for the personal representative of the state. And from my side, if you enter these judgments, I don't have to appeal them all. I could appeal one and not another.
God, find the microphone, Mr. Burns, please. Somebody called him Rotten Burn in the chat. That cracked me up. It's perfect. We can't hear a damn word he's saying.
To be fair to him, he's not here today either. And let's be honest, this is all about hair envy.
Well, the next one, let's talk about the lien issue. Because I
Yeah,
know
let's talk about the
was
lien.
Disagreement in open court. If I have the transcript, I haven't gone back to look for it. What is that? How does that work? And then also, because sometimes I'm asked to put the insurance carrier on the verdict form as well. So talk to me about those issues.
Let me distinguish between set-offs and liens, and putting the judgment carrier on the judgment.
Tuft of Justice, make them use the microphones. We cannot hear this. This is absurd.
The lien is the hospital, whoever has a legal right under their contracts, get reimbursed from the judgment.
Why don't they approach the microphone? I cannot even.
I mean,
Denied. Sit down.
Is there garlic on the microphone?
Someone should find out. This is so annoying.
Nobody cares.
I mean, we need to hear you. We can't hear you. All right, well, while he's refusing to speak into the microphone, I might as well catch up on Super Chats because we can't hear this anyway. Carrie says, thank you so much for your coverage of this entire case. Not just informative, also entertaining. Love you and all your guests. Well, we love you too. Thank you for being here. Laura Bronson says, RA is on live. We know. We're covering his feed. This is his feed we're using, which is great. Rachel Heldingser, thanks for the Super Chat, says they still don't fucking get it. Lots of love from South Africa. Wow. South Africa. Cool. Resist Impulse. First-year law student, age 38. And I got to say, Megan, you're inspiring because I've done action work similar to your efforts recently and can't wait to learn how to use the law to aid advocacy. I love that, Resist Impulse. I hope you do. And I hope that you go into some form of constitutional law so you can defend parents' rights. Oh, they're finally turning up the microphone.
Judge, I think this is a split again. Apologize. I think as to the lien amounts, that is a separate hearing. I think the court's question is, do I need to put any of the lien holders on the judgment, if that's what the court was asking? The answer to that is no, they're protected by statute. So we would have then a post-trial determination on how much they get paid back, but I don't think that really affects the judgment, right? That's something that we're obligated to do out of any recovery we make. And the second question then would be, as the liability carrier, in this case MCIC Vermont, and whether they go on the verdict form. Is that what the court asked?
I don't know who the carrier is or if there's a carrier or not. I don't know.
Yes, sir. There is, and
is Whitney sitting there with his mouth open?
Is under the non-joinder statute that once a verdict is reached, then they may be added to the judgment. However, there's a question about whether they asserted any type of defense to coverage, which my understanding is the only thing they asserted was as punitive damages, which they have a right to. So if we can join them on the verdict form, except as punitive damages, on the judgment, except as to the punitive damages, I think that would be appropriate.
I can speak just to the statute. The statute says that once a judgment is entered, the plaintiff has a window of time, I think maybe 45 days, to take certain steps that would allow them to join a carrier who has no coverage dispute as to something. But I don't represent that insurance company, and I've never seen their insurance policy.
So the issue there would be, I would enter the judgment, assuming we got there, and again, it's an assumption. If we got there, I would enter the judgment, and then the plaintiff would have to take whatever they needed to do. But the issue with the set-off, though, isn't that something I would have to do prior to entry of the judgment?
Well, typically, from what I see, the judgment is entered with a motion for set-off as to mounting the judgment, and that's a hearing, and then there's an amended judgment that pulls it down. You see that most commonly with PIP insurance and things like that. But I don't know how to do a set-off until I see the number. It's funny.
Do you all know that whether you pled set-off and specific as to which party and amount?
I know I pled that I had a right to set off the amount that the settlement was for the doctor's.
I know earlier you did. Judge, I think there's some issues that need to be handled there, but that would be a process of post entering a judgment if it was necessary then to reduce it. The entry of an amended judgment, I think we could probably find a way to do that without burdening the court with any more hearings. I mean, that's a pretty mechanical process. We know how much it is, so.
You get into a bit of an appellate timing issue because you want to make, we would probably have to appeal a judgment and then have a relinquishment just to be safe because of the amounts of this to resolve the setup. But there may be a way to do it from a preliminary order of the court. I'm not sure about that. The other thing I would point out, Your Honor, I've never had to do this before, but if one of these judgments is more than, I believe it's $50 million, we get this point where there's a cap on the supersedious bond to stay the judgment pending appeal, and that might require, if the parties can't resolve that, which maybe we can, that might require some additional resolution. That won't stay the appeal times, but would probably still be an issue with management.
That's upon filing a notice of appeal, then preclude execution, then you would post a supersedious bond. I agree it's capped. What I don't know is capped per party or if it's a total cap, but that's something that I don't think we have to worry about bringing before the court. Either is or isn't by the statute. So in our view, Judge, you would simply enter a judgment based upon the amount that the court determines, again, not prejudging where the court's going to go on this. And then if there were a need post-trial for an amendment, then we can take care of that. But to us, it's extremely important that we get a judgment filed, obviously, because interest and other needs.
Am I correct in saying that interest does not begin to accrue until the court enters a judgment? Or is there a period of time post-verdict that interest would accrue?
Well, that was an issue as to pecuniary and non-pecuniary, as to whether there's prejudgment interest on the liquidated amounts, which would be the past wages and medical bills. Did we determine that?
No, I don't think we're asking for interest, John.
All right. So then it would be simply from the date the court enters it. Obviously, we would prefer to get it entered sooner than later, because we are talking about significant amounts of money here.
Your Honor, one thing I would add on the insurance adding issue is I guess I need to look back at the statute. I thought the insurer had to be added by the time of the judgment. I didn't think you could go back and do it.
That was my understanding.
Within a window afterwards, so we need to look at that, because that would also impact whether that was going to be done. So we'll look at that right away and let you know.
I don't have the statute with me, but I'm confident that it's done after the judgment or separate, because you actually have to serve it.
So we just need to look at the statute, Judge.
Well, here's my thought process. I will let you all know sometime next week whether we're going to have a juror interview. I am not going to rule on any of these other motions before I resolve one way or the other the issue of juror interview. And if I grant a juror interview, I will not rule on any of the downstream motions until after I resolve that juror misconduct allegation. So I'm not going to enter anything until after that issue, because to me it's more of a threshold type of issue.
So, you know, I ordered a full transcript to be the Apple's verdict, and I'm not complaining, but they wanted expedited excerpts, a bunch of them, and so the court reporter has been doing all these excerpts. I think now is about the point where she can begin to fill in everything and start doing a transcript from day one to the last day. I'm sort of optimistic we get that by early January.
Now, is there anything else about the topic of entering a judgment that we should or need to address? Because, you know, ultimately, if I am going to enter a judgment, whenever I resolve all of these motions, I'm going to want to do it as soon as possible. Obviously, if I grant various motions, there might not be any judgment. It might be a partial judgment. You know, I just don't know how it's going to shake out, because I just don't know yet. So, but is there anything else that we need to address? And perhaps you all need to talk amongst yourselves about that set-off issue. Maybe there's an agreement. I mean, I know what I've seen in the paper, but I don't know if that's the true number or not. So,
from our point of view, Judge, the only thing we can ask is the court set a timetable that's saying by midweek, as the court said, I'm not trying to put any deadline on your ruling on the juror issue, but by midweek we submit whatever answer we come up with on that point. I don't want that part to drag out.
wait a second. The answer are you talking about the insurance issue and whether to add? Yeah, my hope is that you all can knock that out here in the next few days and just let me know whatever it is. Now, I'm assuming that there is a question of confidentiality relative to the settlement with Dr. Smith and her entity. So you're going to have to figure out how we're going to communicate that information.
Yeah, and the question is a matter of public record because of state, being part of a state organization, and everybody knows basically what it is.
Well, I mean,
We'll tell you.
Right, but at some point, someone's going to have to formally tell me what it is. And you can't just pick up the phone and call me, because we don't do that. You have to file something in the court file or somehow come to an agreement on how it's going to be done.
Your Honor, ultimately, when you rule on these things, there'll be a number, and it can be adjusted, I think, between counsel. The one thing I was going to say, it seems to me as we're thinking about it abstractly, that could impact it is what your ruling is on Sally Smith, because if they've argued she's not if you would agree with them on she's not an agent, I don't think you can settle.
So is the plaintiff now saying she's not an agent so that we don't have to worry about that if I get there?
I didn't say that. I'm just saying, if you agree with that, I think they wouldn't get a set-off.
Okay.
We're going to settle. I just want to call on medical malpractice.
Okay. Look, let's just refocus in here. On the specific question about, I will tell you this. No matter what, assume for the sake of argument, I say there's no juror interview. I'm not going to make any ruling before Christmas, okay? So that gives you all of next week to figure out these other issues, and then you can figure out how to convey it to me. Does that answer Mr. Whitney? I think it was Mr. Whitney. Did you have the timing issue, or was that Mr. Elegant?
Not me, Your Honor. Well, that's good, Your Honor.
Okay. Does that time frame work for both sides to figure that out? Right. Well, Mr. Altenberg, I see you're packing up. We still have other things on the agenda.
Actually, Your Honor, if you're ready to move to that one, on the sanctions.
Before we go there, I want to make sure I've closed the door on anything having to do with the abstract discussion about the potential entry of a judgment. So, is there anything else on that issue?
Not for the plaintiff, Your Honor.
Okay, so we are now going to move to the next topic.
Your Honor,
And
as far as
This should be sanctions.
Skip to the end.
let's call it the hospital jeopardy type issues, we've agreed between us to defer that, if that's acceptable to the court.
Well, let me go over a couple of things first, because that's just one issue that we have labeled a sanctions issue. You know, I recollect when I was assigned this case a few years ago, I came in and there was a lot of sanction motions that were pending, were being filed, and rightly or wrongly, and you know, I basically started out taking the view that I'm going to push sanctions off to the side as much as I could, and I dealt with some, and I promised you all, both sides, that after trial, if you wanted to light each other up on sanction motions, I would make time for that. Now,
Light each other up.
you know, and I will tell you my thought process then was, well, once we have a resolution of the trial, I will then say, do you still want to light each other up with sanctions? And I made that offer, and so ultimately, if the answer to that is yes, I will keep my word on that. Now, I do know that
Yes, they do.
the question of sanctions is going to be impacted by whether there is a new trial in whole or in part, because then we're back into trial mode. So I get that, but what I need to know from each side, and I don't need a final answer this moment, is are you all going to want to pursue sanctions against each other for all the number of issues that have been filed? And then, frankly, someone's going to have to come up with a roster of all of, you know, I've got some that I know that I've put aside, but, I mean, there's quite a few. And so, you know, and it's both sides against each other, so it's not like it's one side only.
I think maybe the question is, both sides are going to just pack up tents and go home on this without pursuing one another. I don't have authority from the client at this point in time to do that, and I don't.
Which is why I said I don't need a final answer right now.
You know, like everything else, we're going to be dropping things if they're not dropping things. So maybe there's a way to resolve this. We haven't talked about it, and I don't have time.
I think we need to see the final judgment first, Judge, to make that decision, and obviously confer with our clients. We would point out that we have proposals for settlement that at some point we'll be filing and pursuing fees for that. So
Well,
those tie into it or not.
attorney fees for substantive claims is not what I'm talking about. I mean, this is, they're saying that you did bad, you're saying that they did bad, and, you know, sanctions. So I see Mr. Hunter standing up, so I'll.
I was going to make reference to the proposal for settlement matter. There are going to be some issues regarding the validity of some of those.
I assume there would be.
And there's also, in my mind, and I have not discussed this with Mr. Altenberg, and certainly not Mr. Elegant, but in my mind, if there's going to be litigation over sanctions or PFSs or whatnot, there's an issue appeal going on, there's got to be a relinquishment to deal with that. In my understanding, or at least there's an issue about that. So that may factor into all of this.
Or maybe it's a collateral issue that I would still have jurisdiction.
Maybe so.
I'm not putting you on the spot, Mr. Altenburn, but
With potential concurrent jurisdictions, I don't want to tell you I know the answer to that.
I think fees are collateral.
no. Well, attorney fees are collateral. That's easy, but that's on the substantive claims. I'm not talking about a proposal for settlement, attorney fees. That is fundamentally not what I'm talking about. I think we all know we're talking about all the various different claims of sanctions. So I told you that if you wanted to light each other up, I would do it after the trial, and I'll stick to my word. But perhaps, depending on, and like I said, maybe whatever happens on these other motions will dictate it. But perhaps there's something else that you all could come up with. Now, that
begging them.
The
Please
next
don't.
question, which I did not put on here, is should I send you all back to mediation? And should I send you all back to mediation before I rule on any of these motions?
That would be very difficult for us to make a determination on. And we have been spectacularly unsuccessful thus far. Hopefully the verdict would change that. But I think that'd be difficult for us to do before we saw the judgment, from our perspective.
Would I have the ability to send you to mediation on a substantive matter, though, after I entered the judgment? I mean, I could send you on attorney fees, but, if I entered a judgment, or if I didn't enter it, I guess if I didn't enter a judgment, we're doing a new trial, I could send you. That would be an easy one I could do. But if I entered the judgment, then could I then send you to mediation at that point on the main issue? And I'm not sure I could.
The appellate court's going to do it in any event, one way or the other. They have every time I've seen.
I think the 5th does, but I'm not sure the 2nd does.
The second district, every other district has the authority to order mediation. The second district almost never, ever does it on its own, whereas some of the others do it on their own. You would order mediation after you enter the final judgment. I'm probably not going to go with the second district.
I just don't know if I have that authority. And I, obviously there seems to be other issues out there.
We consult on that and advise the court.
Yeah, and I will tell you, Mr. Anderson, this isn't idle thought process on me. This has been an active thought in my head as to whether I should send you to mediation before I rule on any of these motions.
What a waste of time. These people aren't going to mediate. They're not going to come to an
And
agreement.
I'm not asking for a final decision, but
bullshit.
Perhaps as part of the discussions on the insurance issues that we dealt with.
How much is that going to
you
cost
can
the taxpayers?
Confer with your respective clients and then with each other.
Well, nothing.
Yeah, the mediation will be paid
Everybody's
for by...
paying for by their own. It's going to cost Maya money. It's going to cost the hospital money.
Well, but they wouldn't be crying about mediation fees, I'm sure.
Well, this is mediation regarding the sanctions.
The judge is basically saying, "Go settle this. I don't want to hear it." Which is bullshit because the judge is the one, the court is the one that was harmed. And he should be sanctioning the defense for disobeying court orders over and over and over again. They made him look like a chump.
I understand. Okay, well, when you convey the information about the insurance give me some thoughts. It doesn't not have to be agreed to. You can each send me something if you want. Like I said, I'm not going to enter anything before Christmas. So maybe by next Thursday you can file something and let us know. The clerk is closed on Friday, so there won't be anything that can be processed after 5 o'clock on Thursday. I have a case management note here. Is there anything that we need to otherwise address that we have not yet addressed today?
Yes, sir.
Mr. Whitney.
We have a motion to compel that we filed on the 6th. Sit.
You can sit if you want.
We filed
No, go to the microphone.
Immediate jeopardy documents. And yesterday, we
Oh, yeah.
received a privilege
Could we
log,
get
and I believe
those?
the defendant filed a renewed objection to those documents. The court order produced immediately at trial. There were 2 boxes, an inventory provided to us. I'm sorry, an inventory of 2 boxes provided to us. The 2 boxes of documents have not been provided. We would like the court to compel the production of those documents, which we have not yet received, not even the unprivileged documents, now that they filed an extensive privilege log and a renewed objection yesterday. That will inform our decision on whether we want to light each other up on sanctions. It also informs the prejudice against us in not having those documents at the time of the trial.
Well, okay. Well, let me hear from the other side first.
Your Honor, we had the documents in question were made available during trial. The verdict intervened. Apparently before anything could be done with them. They were then sent back. We had to re-get them back. We then went back through them. We never had an opportunity to look at objections or privileged information. We did that. We prepared a privilege log. We prepared objections. We sent those. We were trying to get them out as of last Friday or Monday. I was out of pocket on Monday. Mr. Hughes got ill. By the time I understood that had not happened, we had an agreement not to pursue matters related to sanctions at this hearing. So the material that is not objected to, that was ordered to be produced during trial, can be produced if that is going to move things along. I can get that to counsel either today or Monday, one or the other. But beyond that, we persist in our objection. We would like to have a hearing on that matter as it relates to the sanction motion.
Okay.
I'd make them go get the boxes right
you're
now.
Sending over what you're claiming is not privileged and wanting to
Judge, don't believe
withhold and
them.
have a hearing as to the balance.
Yes, sir, Your Honor, but
They're not sending shit.
we continue to object to having been ordered to produce those materials.
Judge, you told Cat Lady to bring
I
them
know,
in
and
yesterday.
perhaps we can just agree to disagree on this issue, Mr. Hunter.
I understand, and I'm trying to protect my record as far as that's concerned.
No, we can't agree to disagree. You ordered it. He didn't do it.
I don't understand what production will accomplish at this date.
Who the fuck
Be that as it
cares?
may, we are prepared to do that.
Turn it over.
Yeah. You were told to do it. It's like my kid. It's like my kids. Why do I need to do it? Because I done
Mr.
told
Whitney,
you. That's why.
I mean, your side didn't file any motions for new trial or editor or anything else. So why do you need these documents if the court
Is he
ultimately
kidding?
enters a judgment?
'Cause you
without
ordered
any sort of
it.
new trial?
You ordered
Judge,
it.
You ordered it. Lay the smack down, Judge.
Well, there's going to be a discussion
Critical
between
of
counsel and
God.
understand about the desire to pursue sanctions motions. It will inform our decision there.
Why don't we, this is not a ruling. Let me just throw something out and get both sides' thoughts. What if Mr. Hunter sends over the non-privileged documents? I tell Johns Hopkins that they have to preserve.
You've already
those
told
two
them they
boxes or
had to
whatever
turn it over.
Ends up being. And then if we ultimately either have a new trial in whole or in part, we can address the issues on the claim privilege. If I enter a judgment, then you can have a further argument as to look at this privilege log, these specific documents, and perhaps I just do an in-camera as to those few. But I tend to agree with Mr. Hunter, like, what's the point if ultimately I'm entering a judgment? And I hear your argument about the sanctions, and that probably is valid, but what about that, what I just outlined?
That suggestion is fine with plaintiffs.
Subject to our objection, Judge, I will refer.
And I know in the first instance, you don't think you should have to turn them over at all. I get that. I disagree, but, you know.
I should add to this mix that we have an agreement, I believe, with counsel that any production that we make is subject to confidentiality.
And I think we have a confidentiality order, and you can produce under the confidentiality. I'm fine with it. So I will go ahead and direct Johns Hopkins Children's Hospital to maintain those 2 boxes. Go ahead and turn over in the next couple of days the non-privileged documents, and then we're not going to do anything on the claim privilege until we figure out what actually gets entered as far as new trial.
Oh yeah, just preserve the documents, boys. Just that they might fall into a vat of acid between now and then, but you know they're going to maintain them.
And
there's going to be one hair. The Tuft is leaving the building. The Tuft is out of here. Just Tuft of Justice is like, we're done with this.
Yeah, they ended the Zoom already.
I appreciate everyone being here. I know this is a difficult subject, and there's a lot of divergent opinions on it, but I do appreciate y'all's work today during this hearing, and we will be in recess. Happy holidays, everybody.
Oh yeah, happy holidays. Judge Carroll is such a disappointment. What a damn disappointment he is. They deliberately disobeyed. MG Law, you're absolutely correct. They deliberately disobeyed an order of the court. And he has the nerve to say, what is the point of making them obey my own order? What is the point of this now? He should be disbarred for that. How does the judge not know what the point of making the other side obey a court order is?
Did we literally pull a Hillary Clinton? Like, at what point now does it what matter, or what point does it make now at this?
Yeah, at what difference does it make now?
I mean, the Tuft is going to leave. He's going to be bald.
Oh my God. Chris, thank you for the super chat. Says, well, at least Children's Hospital and state and county social services child protection frauds for funding pretend child protection for profit are learning here. Yeah, learning what? Learning how to avoid accountability. Here for the truth says, had to step away for a few minutes. Did I miss J Hatch presenting the IJ? As if. Yeah, they're not going to. They're not gonna. Because Judge Carroll is a pussy. Yep, I said it.
Wet ass P word.
All right. Salt Lake City Bagpiper, I wanted to pull up your chat here. It says J Hatch's position is essentially, we forgot to argue these points at trial. Please give us another go, or maybe even declare us the winners. Yeah, that was it. That was pretty much it. Gio says they did bad. They did do bad, Judge. Made you look like a fool when you demanded IJ report, and they said, no, we don't want to give him to you. Yep, and he's not going to hold him accountable. LA says, I can't imagine mediation would actually work. No, you can't mediate with Dracula.
Things, and by going into mediation, that delays the idea
even
that
more.
Judgment would be entered, which reduces the amount of interest that they would have to pay.
So fucking annoying. Yeah, right, because the interest doesn't start accruing until that judgment is entered into court. So that's a very good point, Brad. Defense has been very disrespectful to the court. Yeah, and Judge Carroll doesn't care. He's a weak judge. And Skoda says, I'm losing respect for the judge. I think I've already lost mine. I enjoyed Judge Carroll during the trial, but afterwards, not so much. Dr. Tracy says mediation will be like when I was forced to go with my sociopathic ex-husband. Yep. That's how this feels. Like being forced into therapy with your abuser.
Why not have them bring the boxes? If he doesn't want the plaintiff to have them, bring the boxes into the courthouse, which is what you were told to do. Again, I go back to y'all were told to do this when Cat Lady was up there saying, but we didn't have to. I wasn't even here when that happened. Like that was the other guy. I mean, again, you were told to have it. You need to have it.
But
If
no,
I
he's
went
but
into
see
a
that
courtroom
he's teaching the entire, legal community there that you don't have to do what the judge says there in Sarasota. You don't have to follow court orders. You can just tell the judge to go fuck himself.
Go fuck yourself. But go fuck yourself.
And the judge won't do anything about it. Judge Carroll is a weak-ass judge, and that's really unfortunate. Judge Carroll also hasn't figured out you can't negotiate with J Hatch. Yes, Squid, that's correct. He hasn't. Or he doesn't care. Lida Legally says this is actually triggering. It's not a mudslinging contest. The defense is slinging mud, and the plaintiffs have real legal arguments. He needs a backbone. Well, unfortunately, he's not going to get a backbone. He doesn't have one. L.A. Lat Cali Girl says, can Judge Carroll be my dad? I could get away with anything. Wouldn't that be great? You could. Judge Carroll would never know. I mean, you could just do whatever.
Question here. If we were all to say send a chocolate spine to the judge,
don't send anything to the judge.
No, I'm just kidding. No,
but
do
that
not
would be
send
funny.
anything. I was joking.
Don't do that. Don't send anything to the court, people. Don't
No.
do it. He will start
No.
complaining that he's being threatened. Chris, thanks for the super chat. Says prayers for the abused child and falsely accused and abused father, who likely will never see full justice in that state. This is a broken system. Well, it's not over yet, but I will say that the IJ order is over. That the IJ fight is over. It's over. The judge has decided that they don't have to turn it over. They simply have to preserve the documents. And you know what? That just means that they're going to have an accident sometime between now and the next time they're ordered to turn it over for the Kushner case. And they'll be lost in a hurricane or possibly dropped in one of those vats of acid that they have laying around there at JHatch where they boil their phones when they are asked to turn them over, or possibly sent to a server farm in Kansas. Is this guy a moron? I'm sorry, Judge Carroll. I guess we should have known when we saw Hare Island. We should have known that this is not a smart man. He should have shaved that thing, and he has, for some reason, fallen for this line that JHatch is actually going to follow through and preserve the documents that they have gone so far to hide. They've spat in the face of a sitting judge, and he thinks that it's all they're going to do what they're told. Is he stupid or something?
Yeah.
I'm having trouble, Mo. Is he dumb or something? Like,
he obviously, did he watch the different trial? I mean, again.
Does he remember how awful they were to him and how many times he had to say, don't look at me like that, and I don't appreciate your tone, and you know, like,
the guy just got done yelling at him. I mean, Old Man River just got done yelling at him. I'd have been like, sir, sit down. I want those boxes brought in here immediately. I don't care what intern you have to get off of Reddit. Bring those boxes here. My bailiffs will take property of them. No one will touch them, but they will be in here, so I will preserve them.
Yeah, or how about just turn them over? Like I ordered you to do. Let's get them in the courtroom and give them to the plaintiff. I'm so sick of this. Preserve nothing. You said scintilla of an odor. You said scintilla, sir. We have it on tape. Here for the Truth says scintilla of order. This is a dumpster fire. Smell traveling worldwide. Do something, judge. This judge isn't going to do anything. Not going to do anything. Clearly. T. Sirzek says, is something more sinister going on? Did someone visit Judge Carroll? He seems beat down. Well, I mean, he's exhausted by this trial. I don't know, but I do see that like he doesn't have any pep in his step anymore, and he's got nothing to say to this defense team that spent most of today yelling at him. And he had nothing to say to that. Like, hey, Mr. Altenburn, how about take it down a notch? Take it down a notch. The hell?
I mean, I don't want to go full Dale Gribble, but did like the state come in and say, if you want to be on the state Supreme Court, all of our funding comes from, the medical industrial complex. And I mean, seriously, it does seem like there was a level of no shenanigans he was taking on the trial, and now that it's a little
It's
bit
all
out
it's a shenanigan. It's a totally free zone to pull all the shenanigans you want now. He's got nothing to say. J Hatch groupies in Law and Crime comments. Well, they always are. That's where they go. They get on there and then they gather in Reddit.
And I bet they're over there celebrating right now that they don't have to turn over any documents that shows that J Hatch did wrong things. Yay!
Well, and the amount of times he kept saying a new trial, that's concerning for me.
That concerned me as well. All right, we did a poll on YouTube that said Judge Carroll will, 1, interview juror number 1, interview and allow discovery, or tell J Hatch to go fuck yourself. 51% of you are very optimistic and think he's going to tell J Hatch to go fuck itself. I say, no way, man. I think it's more likely. I think it's more likely interview juror number 1, 42% of you. It's like split down the middle. I would be very surprised if he allowed discovery. We're going to end that poll and start a new one. Let's start a new one about Judge Carroll takes orders from the Dick defense. Medical industrial complex. Or his wife tells him everything to do. His wife is the boss. Those are your options. There you go. Because I'm sure he doesn't have a spine, but I would like to know who's doing the string pulling. Resist Impulse says judge will allow cell phone of juror before boxes and sanctions of J Hatch. Oh, I don't think so. If he does, I'm telling you, he will single-handedly, Judge Carroll, if you do that, you will single-handedly destroy the jury system in America. If you allow these dicks to take a juror's cell phone and his wife's cell phone and dig into their private communications, which you know damn well that they will put out there on the internet because they are just that disgusting. If you allow it, I will no American in their right mind will serve on a jury. They will walk into there and they will say this: I cannot serve on this jury because I can't be assured that you will not invade my private life and download my phone and and dox me on the internet because of what Judge Carroll did in Florida. If you do this, you will destroy our system, Judge Carroll. And I don't think he cares. And it's unbelievable. Sybil, what are you worried about? I should be careful about my words? Oh, yeah, no.
Go fuck yourself. But go fuck yourself.
What words are you worried about here? I'm an American with an opinion, and I have a First Amendment right to say that Judge Carroll is on very thin ice with this decision. If he makes this decision and he allows these people, the Dick defense, to go into these people's phones, he is putting our entire system at risk. It is bullshit. Why do I have to be careful about what I have to say about it? This is America, ma'am.
Why can't we bring the judges' wives into it when everyone else is bringing everyone else's wife into it? No, I'm just saying.
It's true.
If the precedent is that the juror's wife is now culpable for his if the theory is that we wives control everything, which we do,
that's right.
I'm not gonna lie, but then why can't we go ahead and assume that Judge Carroll's wife puppets him like a giant, ventriloquist puppet too.
Hey,
That's
that's an idea. Maybe the jurors should drop their phones in a vat of acid.
I would. Hell,
so would I. I mean, it would.
Encourage destruction of possible evidence, but they did not issue a preservation order, so.
I don't understand why they wouldn't. I mean, J Hatch did it. If it's good for J Hatch, it's good for the jurors. J Hatch had people in that hospital dropping their phones in vats of acid in swimming pools. I don't see how there's any difference between them and the juror. I really don't. This is so outrageous. This is such an outrageous offense against freedom in America, against our jury system. It is an offense against us. This is against the people of the United States. If we cannot serve on a jury, I know everything's on the cloud, but apparently somehow J Hatch got their cloud to be stored on a farm somewhere in Kansas where no one would release anything. We need to know where that server farm is so that we can put our cloud stuff there so that it never comes to light. I'm escalating the tone. No, I think Judge Carroll did that by not shutting this shit down immediately. This is ridiculous.
Here's the thing: as a person who just got told that they are on jury duty, potential jury duty for a year, which, again, I doubt that I will actually be allowed to jurate with
jurate
with my YouTube, because anyone's gonna look at my YouTube and be like, ma'am, do you wear funny wig? Have you worn a mullet wig? And I'll be like, yes, I have.
Have you mocked our judicial system?
I'll be like, every day except twice on Sundays. And they're gonna be like, yeah, well, we're gonna...
No, he has not ruled on it yet, guys. I know that, but I'm saying if he goes down the road of discovery, that is going to destroy our jury system as we know it. This is a high-profile case. Everybody is watching this case. Every American who has ever served on a jury is watching this case and going, holy shit, I didn't know this could happen to me. I didn't know that some upset dick defense could dig through my private life and then dox me online. This is going to send shockwaves through the entire system. And if I get called for jury duty, I'm going to say to the judge there, Your Honor, I'm sorry, I need to be excused because I'm terrified that one of these dick lawyers here, if they don't get their way from me, are going to dox me online just like they did in Sarasota to juror number 1 in the Kowalski case. And I have no confidence that you as a judge will stop them from doing it because Judge Hunter Carroll didn't stop them in Florida.
To be fair, we are jumping the gun. Maybe, just maybe, he didn't put his big boy panties on today. He lost his underoos. His wife was washing them. And he realized he wasn't going to he wasn't going to, judulate anything, as he was not going to rule. He was not going to do anything. So he's just going to let him blather for a bit. And, he was back there doing origami middle fingers and, doodling and he just wanted to let them feel heard because, sometimes you let the idiots feel heard. That's what they do on Maury, right before they say, you are the father or, you aren't the father. And she's brought 15 people up there and you're like, ma'am, there's like 2 days a month. What the hell? Did you have numbers or something? But back to
it's called the train low.
Well, yeah, that's a whole nother stream. But what he is doing here and what happened to juror number 1 is very scary. And yes, we are jumping to conclusions, and yes, we are getting heated because the fact that a juror's wife has been brought into this, that there are Reddit things and everything else. This juror, spent, what was it, 6 weeks, 9 weeks of his life
12
listening to
weeks. 12
okay, I'm sorry,
weeks.
12. So a trimester of his life, in the thing, we're going to go ahead and jump on a limb and say he did not talk to his wife. But the fact that the other side, I know the fact that I'm being the voice of reason, holy crap, y'all, it is a sign of the end times. The fact that the defense went and found his wife, went into her internet history. I mean, this is a level of
went into their legal history, went way back, and they asked him no questions during voir dire. If I'm the judge in that case and I hear that, I'm going to say, too late, too late. You had your chance and you totally missed it. You missed it. And yeah, I might actually, as Judge Carroll, I might actually interview the guy. I think that that's legitimate. I think it's legitimate to pull juror number 1 into my chambers and in front of counsel and say, okay, we have a problem here. This one thinks that you and your wife were colluding the entire time and somehow involved with LawTube and on the internets. And yeah, let's talk about it. I think that's perfectly acceptable. What is not acceptable is going anywhere beyond that. And if the juror tells the judge, no, I didn't, he has no other choice than to believe him because there is no evidence to suggest otherwise. Everything they put up, everything the defense put up about the juror was a load of bullshit. It was not evidence. It was evidence against his wife who did not take an oath. It was not evidence that he had spoken to his wife about any of it. And in fact, one of the pieces of evidence they put in their motion says, it's a post that he made on Facebook after the trial. And he said, I'm getting your messages, but please give me time because I have not caught up on all of this yet. I have not seen any of this. So I'm trying to catch up and I can't respond right now. That right there is evidence that he didn't see anything online. It was his return to online saying, whoa, 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 I can't even believe this. I've got to go catch up on all this stuff because I missed all of it. I do not like any of this, but I will say this. JC says you're heated about something that hasn't happened yet. I'm upset about the idea that it could happen. I'm upset about the idea that the judge's demeanor did not show me that he is offended by that motion. He should have said something to them along the lines of, I'm only considering interviewing him. I am not even going to consider your request for discovery into a juror and his wife. That's absurd. He also should have said, you have gone way too far with this Nazi stuff and you better knock it off because this is stupid.
I was giggling at chat, but I
was it this one?
Pregnant. Yeah, and then I was trying to pull it up, and I'm like, I am not in charge. Why am I not?
I am not in charge. Oh my god! I can't read that out loud, but it's really funny.
Don't let me be in charge. I always screw up Nick's chat because I'm thinking I'm writing in chat, and I've done something to his screen. So,
oh god. Yeah,
I mean, to be fair to Tuft of Justice, I mean, look, he can't be, guns blazing, middle fingers, the Team America theme song every time, which I would do, which is why I am not a judge, because I'd be like, defense, you've given my middle fingers both standing ovations. I'm going to say no. Now, this is why he could. I would love him more for it. A bald eagle, like right here. I would look, if I was him, I would play it up. I would get a velvet painting of me with a bald eagle in the thinking pose, like next to George Washington.
His face superimposed on Mount Rushmore. The Tuft on Mount Rushmore.
The Tuft in its own Iwo Jima pose with like the little
said more things.
Putting up the.
He could have said more things about how outrageous, especially the Nazi motion was. I mean, he did indicate, there was some indication that he was annoyed by it, but it wasn't very strong. I need to go back and listen again because the sound was so bad. That I missed a lot of it. I mean, and I took no notes or anything, and I can't even get into like I don't even care about the minutia of the remitter and all that stuff. I just don't even care. The new poll is ending, by the way. What you guys have voted. You think Judge Carroll takes his orders from the Dick defense. His wife came in a solid second. But obviously, I think I would have voted for his wife because his wife, clearly we had evidence earlier in the trial that Judge Carroll's wife does tell him what to do. He admitted it. None of you remembered that. I'm very disappointed. He said, I'll let you know what time because my wife has to tell me where I need to be. I mean, come on. It was for Halloween. You don't remember this?
To be fair, Mr. Moe would not know where we would need to be for Halloween either. He'd be like, do the kids have costumes? Is it this year? Like, do we do it every year? Like, he'd be like, do we get candy? I mean...
And for you lovable degenerates in the chat, Locals is back, so...
Yeah, I just was able to open it up again. That was annoying. But it was down for a while, so we didn't get any of our memes from today. I'm annoyed. I'm annoyed by all of it. But you know, my one I have been in contact with some of the team, and my one comment was, you know, I can't believe that this is going on when he ordered them to turn it over. And the response was, welcome to our world the past 5 years. You know, this has been going on for a long time. The judge has been, maybe he was putting on an act for us during the trial, you know, maybe that was an act just so that he would sound a little more balanced than he might be in this case. I don't know, but he has been difficult for them over the last.
If we can't get it from the hospital,
years.
Can't we get it from the independent committee that comes in and audits them?
Well, not just the IJ, it's also the boxes of documents that they're trying to get because they were brought into the courthouse and then disappeared. But that's not the IJ, that's
Twice.
other stuff.
It's related to the IJ.
So do they also know where Hoffa is? Because I think that Geraldo needs a comeback. I mean, like we all remember when Geraldo opened the vault and nothing was there. I think I was 9. It was hilarious.
I remember that.
Like, Mom, what the hell is going on? And why is this man blathering? She's like, wait. She's like, this is very important. We might know where Hoffa is. I was like, well,
that was Capone's vault, not Jimmy Hoffa. He's supposedly Al Capone's vault. Here for the Truth says defense is in contempt of court and no sanctions awarded. This is like impeaching a president. It means nothing. Insert angriest face. Yeah, it means nothing unless you remove him. You can impeach all day long, but if you don't remove after you impeach, nothing happens. Jonesy84, thanks for the super chat, says juror number 1 needs to lawyer up and claim spousal privilege and then go after this Dick defense and the judge if he allows this insanity. Well, the judge has absolute immunity. He has judicial immunity for anything he does while he's wearing his black robe if he's doing it as on the bench as a judge. It's absolutely impossible, almost impossible, to get over that immunity standard. However, I'm pretty sure that the juror number 1 and his wife, I'm sure, have gotten some kind of legal advice, and I'm sure that they're taking care of their own interests as they should be. But there's no one to sue. You heard Greg talk about this in an interview with, I think it was with Dr. Corcoran. Joe had asked, the chat had asked, you know, why can't they sue the defense for defamation? And it's because of this thing that you can say anything in court. If it's part of a trial, none of that stuff is considered defamation. So lawyers can lie like crazy in court about anybody, say anything, and if it's related to a trial, they get away with it, period. There's very few exceptions, and nobody thinks. Actually, I'm not sure there is no spousal privilege in this instance, Blue Ain. I actually think there is, and the plaintiff put it in their response motion. Yes, thank you, Campers for Life. It's litigation privilege is what that's called. But spousal privilege, I think it does apply. And I don't think that, Marta, we need to find this out. It's funny that Reddit feels the opposite to you, Megan. They feel like this hearing didn't go well for the defense. Should we go and browse the the weirdos on Reddit and see what they have to say? I'm totally going to do it. Let's see. Reddit.
You know, I have a Reddit account, and I feel shamed.
You feel ashamed for having an account?
I feel shamed by all the anti-Reddit hate.
I have tried to get on Reddit, but it's confusing, and I don't really have time to listen to people. Is Reddit the place where people go when they want more characters to fight than they have on Twitter? Because that's all I kind of figured out it was.
Quora is a really big battleground.
Okay, here we go. Let's see. I'll read some of these, some of the obscene rantings of the rabid Reddit page that is pro-defense and got 2 people to show up at their protest today.
Here we go. Did Judge Carroll just say J Hatch battered Maya? When Altenburn said that if Maya would have left J Hatch, DCF would have placed her in another hospital and that hospital would be here today, Carroll said, are you saying that another hospital would have battered Maya? He basically accepts it as fact that Maya was battered and treated poorly by J Hatch. He is acting as an agent for the plaintiffs rather than ruling from an impartial legal perspective.
That was a matter of fact-finding, ma'am. And the jury found that they battered her. Because they did. They dropped her. They admitted to it. They admitted to the battery. They admitted that they were liable for some of it. They just don't think they're liable for all of it.
I love how everyone has become a CRPS expert, and me having it, I still don't know everything, but like people on Reddit have become experts in
Why
a field
would
of
someone get a
medicine where
CRPS
they're
lesion on their
experts.
forehead, Mo? You explain this, Mo. Why would someone get a CRPS lesion on their forehead? Where is that documented in the medical literature?
Well, let me see. As Sally Smith, I printed out like 4 articles from Parenting Today and something or other, and I didn't read them yet, but I have them highlighted, and CRPS is something or other, but I have the articles, and I work for J Hatch. I do. I really do.
You know, if you just go to YouTube, you can find all kinds of information on CRPS, and that's where I go for my information. And that, you know, everybody knows YouTube is way better on medical advice than anything you could find from specialists. Duh.
Not Dr. Chopra. I mean, he's only been researching it for years, but he has no idea what the hell you know, regardless of the fact that I called him Dr. Gupta, because yikes for me, but.
That sounds like intentional racism. Sorry.
It was. I
did
took
the same
away
thing.
one of my
I did the
privilege
same
points.
thing. I did the same thing. I called him Dr. Gupta, and I was like, "Oh
I got
God!"
him mixed up with
I
the
did
guy
that.
from CNN who always comes in and doctorates. But yeah.
Oh, Law and Lumber is in the chat. Law and Lumber. I know you did say it. I will give you the credit for that. Hate to say it, but remember when people were asking me about the likelihood of sanctions? Remember my answer, which wasn't a fun one to make. Yeah, I mean, and at the time, I remember thinking, yeah, there's the chances of him actually giving out sanctions are not good. But here's what I'm asking for, Rob. Answer me this, Rob. Why the hell wouldn't he just make them turn the stuff over? Like he doesn't have to give sanctions. But why would a judge allow a defense team to defy his orders over and over again and not force them right then to turn over the boxes? How dare he say, oh, okay, we'll let you just preserve that evidence that you're so desperate not to turn over, even after I ordered you to turn over anything with even a scintilla of an odor regarding this. You know? All right, Mo, take over the show. I'm getting a very important call. Hold, please.
Oh, okie dokie. Well, I mean, look, here's the thing. We saw this with the Brooks trial. We saw Daryl figure out exactly how far he had to take it with mom judge before she gave him 15 to 800 chances. Like, I'm going to give you 17 more chances, and I'm going to say if you would like to come back to the trial, you have to be a good boy. And he'd be like, I'm not even going to. Oh, yes, I can boost mine. I was low, so I wouldn't go over the court. But this is definitely, look, again, as a person who has CRPS and still doesn't understand all of this, I love how everyone has become an expert. It's like now everyone's an expert in Ukraine, though please explain I want 3 people off the street to show me where Ukraine is located on a map for 5 seconds. There can even be a U and a crane, the bird, on the country. I'm telling you, for the love of all that's holy. And he needs to show that the court has, it's the same thing when you don't negotiate with toddlers, bad people, or the government. When you say something, you say something. It's, as a parent, if I keep telling my kids 5 more minutes, they're going to learn I don't mean what I say.
Mm-hmm.
And they can get away with stuff.
It was so terrifying. My wife was telling Leon to stop doing something. It was, he has the silicon plates that stick to the top of the table.
Oh,
and
yeah.
He was lifting them. And we're like, no, don't do that. And then she goes, no, don't do that. And then I bring out my big, deep voice, and I said, Leon, stop. And then you just see his face drop, and he starts crying, like, and I was like, oh my God.
I've been sitting there thinking I was in the show and hadn't added myself to it. I'm just listening, sitting in the green room by myself, just listening. Yeah, I mean, God, look, I kind of wanted this too, Becca. I wanted at least a verbal admonishment. That's it. That's all I wanted. I wanted.
Shame.
Yeah, where's my shame bell? I wanted him to bring out this. Shame. Honestly, it's just awful to me that we can't even get him. He was so weak sauce that we can't even get him to say, why didn't he even question them about, I did order you to turn this stuff over. I did. I said, if it even has a hint, a scintilla of an odor, why didn't you do it? And for them to then use the argument, well, what difference does it make now? What difference at this point does it make, in their best Hillary Clinton voice? I think that doesn't fly. And why I just think this judge has proven now that he's just weak, because he could have at least verbally told them, this is not what I asked you to do. I asked you to turn it over. So let's go get the boxes right now. Go have them. It'll take you an hour to get there and an hour back. Fine. We'll take a break. And in 2 hours, we'll meet me back here with the boxes and turn them over. This just keep them in a storage house somewhere. Rob, are you at all worried that the storage house where they keep the boxes is going to get flooded or ruined by a hurricane, or possibly bathed in acid that the J Hatch staff has laying around for inconvenient phones?
It's safely being stored next to, Dr.
Dr.
Chernobyl.
Elliott's reports. Chernobyl.
Right next to Fukushima, and
3 Mile
if Godzilla
Island
happens to attack.
What will happen is when they come back, they're like, well, remember we asked, the judge ordered you to maintain the records, and they'll be like, no, we have no recollection of that. No one told us that. I wasn't in the room when that was Judge, I wasn't here when that order was entered. I don't know.
Judge, we buried that Dracula and then we staked it in the heart. I don't know what you're talking about.
If I was Anderson, I would have had the transcript and I would have said, here it is, right here. You said it.
Oh, God.
I would have been I am the type that if a person in authority says it and then someone else, I would have had it, you said on this date, I want them here. We have now taken, it has now been this. We've gotten a judgment from the jury. Why are those boxes still here or not here? Regardless of the privilege thing, those need to be in the courtroom, Your Honor.
I don't understand it. I really don't. Rob, if you're not busy and you want to call in, you're welcome to come in. I'll send you a link on Twitter if you want to explain this to us, because we're not lawyers. So maybe we don't understand. Maybe we just don't get it. But I really don't. If this is the way that our justice system, our judges behave on a regular basis, where they just allow lawyers to disregard their orders. I have been a witness to people disregarding judges' orders, and they get thrown in jail. I'm talking about, you don't follow your custody order that the judge put in, and they come drag you out and from your bed and throw you in jail. I don't understand how it's okay. Like, judges can come down hard on the citizens of this country when they don't follow orders, but they don't come down at all on lawyers who don't follow their orders. Is it different? Is it different when a private citizen doesn't follow a court's order versus a lawyer? Is there some kind of favoritism there that I was not aware of before? Is it normal for attorneys to just give the finger to the judge when he says, bring me this thing on this date, and then nothing happens? Like, you could just turn to the judge and be like, you know what?
Go fuck yourself. But go fuck yourself.
And nothing happens?
Why I can't be a lawyer, because my face is contempt all the time.
Honestly, like, what is the problem? Why does this happen? I feel like I would not be treated that way if I went into court and the judge ordered me to turn something over, and I was just like, yeah, I don't think so. I don't think I'm gonna. I don't really see what the point of that is, Judge. I just feel like we have a double standard here, and I don't like it. Let's go back to Reddit, because that was funny.
Yeah.
And I would rather laugh right now, because
Did
if I
someone
don't,
just say
I'm going to
darn
start crying.
tootin'? Oh my God.
Darn tootin', another hospital would have been accused of battering Maya. The evidence would have been exactly the same. Maya's word and Anderson's exaggeration.
Oh my God. How do they find these people? Where do you find these people for this Reddit page? Do you dig deep into it's almost like these people come from an alternate universe where John's drop kids did not admit that they dropped her.
But I do worry that my, Garth with boobs is fueling some fantasies of some kinds on dark corners of Reddit. And I'm a little afraid. I mean,
oh my God.
Y'all, if it floats your boat, I mean, she is there for the taking, but I am afraid.
I like this one.
Tell me you don't know what you're talking about without telling me you don't know what you're talking about. Final judgment has not been entered. This morning's hearings are for motions for a new trial. Statement of bias by the judge are still a matter of record that will be considered by the appellate court at this phase in the proceedings.
Man, these people have a lot of energy. Where do they get this energy?
Yeah, I'd be really skinny if I had all this energy.
What else do they have?
Okay, that's pretty funny.
That's a good one. I need to take a screenshot of that so locals can make a meme. It's almost a meme all on its own. It doesn't really need anything.
It's almost like those S's look
exactly like
weirdly like.
It's so strange. Oh, that was
actually
funny.
Middle daughter stole mullet wig
like
last
Greg.
night.
That face just.
That's not Greg. That's Elegant.
Oh,
that's
right.
Tom Elegant. Oh God, this one. Leaving treats at the nurse's station at
J Hatch to let them know we support them. Justice now! Justice now!
Why must there always be the fist?
I really don't know. I wish I knew.
Also, chocolate? What if someone's allergic?
Wow, that is wonderful. My partner works for a company and sometimes passes through JHatch for business. They said this is so sweet and they think the nurses will love and appreciate it more than you know.
Aww.
What a great idea. What if those of us who are out of state or too far to hand deliver something sent cards to the hospital thanking them for their service?
You know, like they're in the military. They're doing God's work over there, dropping all those
They're gonna
kids.
have chocolates, drop children, like, oh, that kid's coding, but chocolate. Oh, guys, there's chocolate code. What are you talking about? There's chocolate in the break room, along with fist flyers. Come on now.
Oh man.
Also, you know, when you do good things, I know this is an idea that has been lost, but you can do things and not put them out on any sort of social media. You can do good things and not blab about them. It's called just being a good person.
But of course, this was not about that. This was about advertising for their little rally that didn't go so well. Let's look at their little rally sheet here. So they were trying to get people to show up at their little protest this Friday.
Well, for chocolate, I might have. For Ghirardelli's, I mean, that shit's like $7 a bag. I might have gone to a
Rally for justice this Friday. Rally for justice, everyone. We are mothers. We are asking that the verdict in the trial of Kowalski v. Johns Hopkins All Children's Hospital be overturned due to evidence being excluded from the trial and blatant juror misconduct.
But this is truly my favorite part. This is my favorite part right here. Are you ready?
Oh God, please.
Because well, my voice mod's not ready, unfortunately.
JHatch took care of Maya.
Oh my. I didn't know you took my voice and made it a voice mod.
That's Scary Teddy. Do you sound like a Scary Teddy normally?
That's probably from Five Nights at Freddy's.
Yeah, it is, I think. It's supposed to be scary. Was it scary?
Not like
I
that.
don't know. Anyway.
I think personally, they that putting that line on there, JHatch took care of Maya, was the dumbest thing they could have done. Like, what? JHatch, yeah, we know they took care of her. They dropped her, they tortured her, they stripped her and took pictures of her. Wow, guys.
In the sense that the mafia takes care of people too, but I mean,
right.
And
exactly.
you know, the CIA takes people to dark sites. I mean, yes, they take care of them.
Look at this, Trader Joe's peanut butter cups. They're like, it's like they're bribing them to come to the rally, but no one. The best part is no one came. In fact, that's not entirely true. We do have some photographs of the two protesters that were there. Let me see if I can pull that up for you, because we do have proof of the protest. We've got this one. Here we go. There we go. There it is. There's the one. There's one protester there. And then we found the other
visual
one.
proof that she is wearing a bra, and yet no support is noticed. That is that is a feat.
All right,
Everyone
here's the other
supported
one.
her like her bra failed to support her.
And here's protester number 2. Protester number 2 spotted on the lawn. Yep, there we go.
Well, she. Oh, for the love of God, you know, just why?
No bra, all mask.
No, you can see her bra lines. She just chose like no support. She was just
All
like,
right,
you know,
let's just check this out again. Okay.
because you can see
Lord.
bra line, but them boobs are way south in Florida. They're snowbirds.
Well,
They
maybe
have
she's
gone
wearing
south
one
for
of
the
those.
winter.
Maybe she's wearing one of those sticky ones. Maybe that's it. Maybe it's the sticky ones. You know, the sticky kind that you can get at for the evening dresses. Maybe she's got like a shoulder problem. I don't know.
Those look like resistance bands that have been 10 years past their time.
The older
Look, it
I
was
get,
laundry day. And
the
she
older
was
I
like,
get,
look, it was
the more what's the word I'm like sympathy I have for the sagging problem. Because my God.
Look, the more I identify with the nutty professor's grandma running through the field with like the socks and the and the tennis ball, but still, come on now.
It's not good. It's not. I mean, and at some point in your life, if you're not strapping those puppies up with like, industrial strength,
50-mile-an-hour tape.
what wired steel boned, contraption, you're dealing with, I don't know, somewhere down here, which is just
Look, gravity is the thing.
John's drop tits.
Now there's a t-shirt I would wear.
Johns Hopkins drops tits. Oh my God.
Look,
drop them
it
like
was
it's
either buy all
hot.
the
Drop them like
chocolates
it's
or buy a
hot.
new bra, and she bought all the chocolates in solidarity. She's like, Haynes from '84, you're here with me.
I'm going to
bring,
hell.
Peanuts
When
into
is-
a children's hospital.
When is? Oh my God, you're right. When is their drop anniversary?
It's new advertising.
50 years ago, that's what it was.
Oh God. Yeah, rebar. Thank you, Debbie. Yeah, and I have total sympathy for that woman because I am dealing with the same issues. Meg says that bra gave support just like the hospital gave support to Maya.
Look, if you are busty, you know that we have like 73 iron hooks, like the lunch lady. If one of them hooks go out, someone's losing an eye. We have been warned when you leave. Like if the elastic goes out, you need to buy a new bra because someone's going to lose an eyeball.
It's
if
true.
One of these metal hooks goes out.
Also, are you ever surprised at how worn the brassiere gets? Like it's like it's hanging on for
goatee is
dear
like,
life.
yes, I am.
The hooks in the back of my bra actually get bent. It's incredible. They get bent out of shape. Like they're like, we're done. We're giving up. We cannot do this for one more second. And I'm like, how did these get bent? I don't understand. I don't know.
The eye hooks are like, ma'am,
you're gonna need a bigger hook.
Like, ma'am, you're shaped like, your boobs are like Chris Farley's when he was the lunch lady. You're gonna need at least 3 more levels of hooks here.
Look, Criminal Mind says there's a 10% drop per year on average. That terrifies me. It terrifies me. The chat says, I like how the topic just shifted seamlessly. Speaking of seamless, we can't wear seamless bras either. You can't, when you have jugs this size, you can't wear seamless bras. You know why? Because there's no rebar in them.
I have asked people, I am like, look, can I donate them? Like, I am willing to share with those less boobed. I don't want them. I would like a flat chest. I would like, to go out with nothing. Like, just.
Wouldn't that be great?
Oh my God, you have no idea.
I've never been able to do that.
The amount of crap
ever.
I would get into, like, look, I'm all for modesty and such, but like tube tops every day.
I can't do any of that. None of that.
No.
In fact,
and then they
I think it was this summer.
Support added. I'm like, no, the hell, it's shelf bra.
It's a
bra
shelf.
does not. Yeah, no, that just means you have a uniboob. Thank you so much.
Right? Uniboob. IT goatee may have gone away. Oh, lawn lumber. Wait, hold up. Yeah, we're talking about boobs. Are your boobs sagging yet, Rob? We have sagging problems over here, and we're talking about boobs. But we can go back to talking about Judge Tuft and how weak he is at any moment if you want to join. I've sent you the link on Twitter. We don't have to talk about boobs, but we are doing it.
For some reason, we got sidetracked. I have no idea why.
Well, there's my contribution to the problem in the Twitter chat.
Where?
Oh, God.
In the Twitter chat.
In the Twitter chat. Oh God, the Twitter chat, the side chick chat.
Mm-hmm.
Believe. Wait, I have to share this. Believe in your codes as much as this woman believes in her blouse buttons.
Oh no.
This is the problem we have every time we try to put on a button-down shirt.
I don't wear button down, and she's wearing white. How in the world? Like
I don't know. I don't think she's wearing a bra either. I feel like I can see protruding nipples, but much like that congressman who was so disgusting with his protruding nipples. That was the greatest tweet that Donald Trump ever made. About who was he talking about again?
I thought it was Governor Cuomo. Governor Cuomo with
his protruding nipples were terrible too. But there was a Trump tweet about protruding nipples. Hold on, I have to find it. It's the best thing you've ever seen. Barney Frank looked disgusting. Here is the actual tweet. This is not a joke. This is real. This happened, and this is why he should never have been taken off of Twitter. Barney Frank looked disgusting, nipples protruding in his blue shirt before Congress. Very, very disrespectful.
If that's all Congress had to worry about, I
we have to find the picture. Yeah, okay, so now you have to see the picture because the picture is so funny because it's so true.
Oh my.
What in Jesus' end of... What in... God's
Rob's never
name
going to join this stream now.
I've never even met Rob, and now he's like, I thought I might...
Rob, you can't join the stream now. You should probably stay away at this point.
To be fair,
you can't be associated with this kind
when I
of
was
degeneracy.
nursing, I think I answered the door like this a couple of times because you'd get started nursing, and then someone would come by the door, and you're like, for God's sake, he does need a man's ear.
It looks like he was in a hospital or something, and they just threw a suit jacket on him.
It does kind of look like he's puffing out. It's like when you wanted to have boobs, like right before you got them, and you would do one of these things, like I must increase my bust. And then you got them, and you're like, what the flip did I want these stupid things?
Oh, can you believe he showed up like that? My God, Barney, what are you doing? What are you doing? This is also true. Rob is getting married. He needs to get used to the boob talk. That's true. Rob, you might want to consider that. You're going to have to put up with this.
Need to know for marriage is when the bra comes off, it is not time for fun time. That means no other activities are happening outside the home that night. Like Mr. Mo knows, like, hey, you want to go to Walmart? Oh, you took your bra. Okay, no. That means we're home for the night.
That means no other activities are happening.
Well,
I so
the
rarely
best
get to
moment
take
of your day.
I very rarely get to take it off. I have to wear them to bed too.
Well, same. The other
Because
attorneys.
I literally cannot walk around without a bra. It's just
It's a parting of the Red Sea.
Rob says, thank God for AirPods or other attorneys in my office would have several questions. I'm sorry, we'll stop naming you.
Yeah, sorry.
But these are helpful marriage tips though, Rob. Really helpful tips. It's true. What she's saying here is true for most people. I'm just one of those people who never takes off a bra, except for maybe in the shower.
You mean maybe? Wait a second.
That's how you save on laundry. You just don't even have to throw it in the damn thing. You don't have to get the little bag and...
My grandmother actually showered in a bra. I've actually seen her do it. She always told us, because she's built, we're built just like her. She always told us, if you want them to stay up there, you will never take this off.
Law and Lumber, yes, these are helpful marriage tits. And I'm just going to throw this out there just for your safety. If she ever becomes with child and they get bigger, they are not there for you to touch. Do not touch them.
Touch them.
And just for your safety again, If she happens to go into labor and she's hooked up to the monitor, she indeed knows when she's getting a contraction. You don't have to say, "Ooh, that's a
It's
big
coming.
one. Do you
Here
see
it
it? Do you
comes."
see it? Oh my God, that must really, really
Phrasing.
hurt." Well, yeah. She knows. She'll know. You
That's
don't
what
have
she
to.
said.
Just to help you out, because Mr. Mo may or may not have, barely gotten out alive with some deliveries. So
You know,
I'm just
the
letting you
tit
know.
growth, the pregnant tits is a real, it's hell on men. It's really not fair, especially
it
for the
is not
ladies
fair.
who have smaller size boobs and suddenly they get giant. You can't touch them. She will scream in agony. She will scream and hit you with something.
The forbidden buffet.
It's just not, it's not okay. It's like a bad joke. God's bad joke.
Yeah, God really does like to make fun of us. So, yes. We
We have to take down Barney Frank. I can't look at those disgusting nipples for one more second.
So yeah, if just for your safety, I'm just letting you know, as I've been there 6 times, she does in fact know when she's having a contraction, even though the monitor will tell you, just don't point it out. She does know.
Oh, How to Avoid Murder by Megan and Mo. Yep.
And when she says everything is...
Look at this one.
Yeah.
Don't ask the lady in labor if she peed herself.
Yeah.
Can't touch them? No flipping way. Uncool. No, because it's excruciating. It's
Yeah, they
excruciating.
hurt.
Imagine that something on your body just grew twice its normal size and the skin is just stretched beyond what's bearable. Like the skin doesn't just grow with it. The
Poor
skin
Rob
does
is
not.
he's like, I'm not getting married anymore. He's like, I'm getting a puppy.
We're good at this. So Chrissy was pregnant, and when Chrissy's pregnant, Chrissy Mayer's pregnant. And
I did not know that.
Yes, and last
I've
show
been
I was
out of
on
the
with
loop.
her, me and the other ladies were like giving her the
God.
horror stories. Everyone's like, "Well, now you've terrified her." I'm like, "She has to know these things. You must know them going in." Anyone who says to you everything's going to be fine and it's going to be no problem is an asshole. Like this is something you need to research and make sure you know about. Like there's things you shouldn't do when you're going in to give birth. One of them is take that awful Pitocin crap. Don't take that. It makes your contractions harder and longer.
That's what she said.
And you shouldn't do it because it's awful. It's just terrible. That Pitocin stuff is just for doctors who want to rush you so they can get on the golf course. You don't need that.
Yeah. Now, I will say that, look, at some point, modesty goes out the window. So,
I have a feeling Chrissy won't have any problem with that.
I was about to say, if you're at a teaching hospital, I mean, pretty much, like, you don't care who's down there. You're just like, someone catch the baby. Or at least about baby 6. I mean, I was just like, I don't care. Just someone catch him, okay?
Don't drop him, for the love of God. Just don't drop him.
Well, don't go to J Hatch.
Yeah, well, that's why I was like, just don't be in Florida.
When our son was born, I was almost mortified because they wrapped him in a sheet and then literally like a stork pulled up for all 4 corners and he's covered in blood and I just see this sheet move over to the scale and I'm like, oh God.
Well, the nurse in our case, my last baby, Hangry, he came out, they plopped him on my chest for like, I don't know, not even 30 seconds. And I was I was in so much pain because I had no pain medication. It wore off. And this nurse comes over and he's crying just fine. He's doing his soft baby cries. It's normal. He's breathing. He's clearly breathing. This idiot nurse comes over with a scratchy rag. And I could see it right in front of my face. It was right here. This looked dirty too. Puts it down on his little tiny baby skin chest, newborn baby, and starts squeezing and twisting. Ugh. He immediately goes like this and then starts to scream because she hurt him. Next thing I know, that nurse is going, we need to take him he needs to go to the NICU. He needs to go to the NICU. And my midwife is like, hold on a minute, just give her a minute. Cause like he had just been there for like 30 seconds. This nurse grabs him away from me, takes him over to the thing, and starts doing all the measuring. She cuts him with the measuring tape, a paper cut on his baby fine skin after just squeezing his back.
No.
He starts screaming again, and the midwife is like, bring the baby back here. Bring the baby back now. They get into an argument. This nurse won't do what she says. I am like, are you kidding me right now? Finally, after the midwife yells at her for like 5 minutes, she brings the baby back and gives her to me. And then I hear them all hush talking in the corner. And I'm like, what is happening? And eventually they come over and say, okay, we need to take him and have him, we need to have him looked at, and we'll be right back. They take him to the NICU, and sure enough, he has blown a hole in one of his lungs.
Oh, no.
How? Because she squeezed him like that, and she hurt him.
No.
And he did not have a hole in his, he had a collapsed lung because this woman did what she did. That did not need to happen. And in fact, they really screwed up because risk management didn't get a hold of them and tell them to change their story and just lie to me about some shit. And by the time I got to talk to the NICU doctor, I guess they hadn't got their story straight. And I asked him, how did this happen? And he says, oh, well, your son is a big, strong boy. He's big and strong. He looks like a giant in there next to all those NICU babies, doesn't he? And I laughed. I said, yeah, he does. He looks like a giant baby. And he goes, well, he's a big, strong boy. He's a little too strong, and he cried a little too hard, and he blew a hole in his own lung. And that happens. And I'm like, oh, except it didn't need to happen because I'm a witness. So is my husband to why he cried too hard. Can you believe that? He had to spend 4 days in the NICU. They forgot to tell me to pump so the milk would get going. And because I was traumatized, I forgot to even ask. And so he wasn't getting breast milk or anything for 4 days. Luckily, I got that working, but still it was like these people. Anyway, I didn't have to pay that hospital bill. You can imagine the type of letter I sent them. You've seen some of my press inquiries. Well, this one was way worse.
Did you fold it into a middle finger or was it sent like with some lube to make it a little...
Mischief Manager is a redhead. Epidural wore off before delivery of mini Mischiefs 1 and 2. I very wisely keep any complaints of tummy aches to a minimum. Oh, yeah. So that thing about being a redhead is true.
Yeah.
That
you eat lidocaine. And even though I'm a fake redhead, I do still have... Apparently, I've dyed my hair enough that I've internalized my redhead identity. And yes, I do eat lidocaine.
That is so bizarre. The whole origami middle fingers. You're so funny, Mo. But no, I did have one hilarious line in that letter that I wrote to the hospital that said that nurse should only be allowed to work in your morgue where there are no people she can actually harm. No people. Those people are dead. So whatever she does to them will be fine. But the people who are not dead, she should be nowhere near. Nowhere near. You know, not only did they pay my hospital bill, but they paid for my newborn photograph session because we missed it because he was in the NICU. You know how would they take pictures of the baby? I didn't get any pictures of my baby because he was strapped up in the NICU to all these machines. And that same nurse, before she was removed from my case, I went to go see him, and I'm supposed to be allowed to see him in the NICU anytime I wanted to. I go in there, and I'm for the first time seeing my baby, and I'm trying to talk to him. She comes over and she goes, you know, you really shouldn't be here. It's not good to get him excited.
Oh, Megan, I said I would be in orange. I'd have to dye my hair brown. It just wouldn't go with the red.
This is my baby. And unless you plan on dragging me out of here, you better just back off. I'm going to be here. He's not excited. I'm calming him down. He knows my voice. How about you just back the hell off? He doesn't want you here. Good.
He knows I'm angry all the time.
Yeah, he's used to me. Oh, that woman.
Is trying to figure out what the hell we're talking about because she's overhearing everything and only one side of the conversation.
Well, she's not hanging on our every word, watching our streams. I think I'm disappointed. No, I'm just kidding.
She's working, so.
Well, so she can't, obviously. Oh, yeah. It's not good when you get treated poorly in a hospital. I know how it is, and thank God I didn't have traumatic outcomes, and he was fine, and his little lung self-healed.
Yeah, but
it's bad.
It goes back to, again, these are people with whom we go in a very vulnerable position, whether you're in labor, whether you have a child who has a complex medical case. I mean, I understand we get passionate and we get upset because these are the most vulnerable times in our life. I mean, you're going there and you expect, you hope, you want, you expect that these people are going to put and take care of you. You are vulnerable. You don't know all this medical stuff. You don't know everything that's going on. I mean, it was just like when the guy with the spinal stimulator was trying to gaslight me. Well, all, the patients that I've had, have had great results with this. You're the only one that's ever had bad results with this. And then I go to the physical therapist and he's like, no, most of my CRPS patients do not have a good outcome with these things. You expect these people to be on the level, and then when you find out the level of gaslighting that you have, it's eye-opening, and this is what a lot of people, I think, are waking up to, is that there really is a disconnect. We have thought all of these things about the hospital, that they're there for the greater good, and it looks like they're just there to cover their asses.
Yeah.
Yes,
Oh,
Fry.
Fry. Hi, Fry. Is he
He's
getting?
like,
Is he?
"Mom."
Has he tripled in size since the last time I saw him?
Let's see. Fry Berto. Fry. Come on.
Oh,
Other
look at his head.
Is he a
He's
Belgian?
already. He's so
Yeah.
big.
He is definitely not a Pomsky.
God, he's gonna be the size of Marmaduke by the time we're done.
Yeah, well, I'm waiting till after the holidays, and then I do have someone coming in to see if he would be a good temperament-wise, well, just with any training, and then, because, he needs to learn the word no at some point, but stability, service animal, and other things, since he's definitely not a Pomsky.
Rumble has a good joke for us. Penitent Tangent, thank you for sending this one. What did one saggy breast say to the other? If we don't get some support soon, people are going to think we're nuts.
Yeah, we tend to.
Oh, God. Oh, man. All right, we got a super chat here to get to. Let's see. Thank you, Forever Wander 03, for both births. I didn't get an epidural in time because no one would listen. And I'd finally get them to check me, and then they'd go pale and say, "Oh, you're at a 10." Yeah, that happened to my poor mother when she was in labor with me. I was her third baby, and if you have had more than one baby, they come pretty quickly after the first one. So you gotta
listen to us.
You gotta listen
We
to
know.
women. My mother goes to the hospital and she's like, "I'm going to have a baby like now." And they're like, yeah, you're fine. You're not going to have a baby for a long time. And there was no room available. So they had her strapped down to a gurney. This was in the 70s. This was 1976 when they would still strap women down, like put you in restraints onto a gurney. She's in the hallway and she's screaming, "The baby is coming. The baby is coming. Now the baby's coming." And this nurse finally comes over there and looks under the sheet and goes, "Oh my God." She goes, "Oh my God, the baby's coming." My mom's like, "Yes, I've been saying this. This poor nurse delivered me in the hallway of the hospital. The hallway, people.
Not have an eraser. No.
Our medical community is not exactly
I love the
always on top
student
of
nurses.
things.
Why I always get a student nurse, because I look them dead in the eye and I say, "Look, I go from 0 to fully dilated in about 3.5 minutes. So when I tell you it's time to go, I'm like, look, I've been here. Like, I should have my own wing, all right?" But I always get the student nurse and they're doing one of these things, running down the hallway, and I'm like, "Oh my God." So I look at Mr. Moe with the last one. I'm like, I hope you have catcher's mitts or someone somewhere, because because the student nurse is like, "Oh, don't breathe, and I'm like,
too late.
Jay Hatch now hiring kid and tit droppers applications inside. Thank you, Locals. Locals is back up. The memers may begin. Do we have any new? Oh, we do have some more memes. Okay, here we go. Did someone say IJ report?
Like, they've never
What do we
seen
have here? Oh, this is so good. Maya, we can take care of Maya. That's what I mean. I mean, the way they say it, it has a whole different connotation. Reddit, when you say it, it doesn't mean what you think it means. It really doesn't. Where's my button? I have that button.
Inconceivable. You keep using that word. I don't think it means what you think it means.
Oh, Locals, this is uncalled for. What? This is just uncalled for. YouTube's not going to like that one bit. It wasn't my fault. I didn't make it.
Yeah, I didn't mean to start the chat out or the stream that way. I just wanted to know if we'd actually found out if we'd found the real, group, underground group in Reddit. Oh, where'd you? Her internet died.
Up and dropped.
She's like, they're like, oh, great. Leave Mo in charge. This will not end disastrously. But on a good news, I did find a new doctor who in fact does work with CRPS patients and is out of the largest learning hospital in Indiana. So yeah, they've got a bilateral, oh gosh, what is it?
Whoop.
Ganglion.
Yeah, whoops is right.
We're going to have to talk about the placement of the power button on this tower.
What? Did you kick it?
I hit my toe. Damn it, Brad. Why did you give me a tower that has this fun little button that my toe can push? You know how I am about buttons.
Yes.
Yeah, why did you leave her in charge of anything, Brad? It's really your fault. You should.
Well, look at this now. Nothing is working either. My buttons don't work. I'm gonna have to redo this. All this shit is wrong now. Oh God, nothing is right. Everything. What? Something did not work as expected. Yeah, I know. I know it's not. Share this report to it. What? Just close that. Can we please not do this right now? Everything's frozen,
I'm feeling,
Brad.
Miss Emily, I'm feeling much better with the stim out. The stim was awful torture. I know it works for some people, not for me.
Oh, it's so frustrating.
Yes, Indianapolis, Sarah. So it's good. They've got me scheduled, and this doctor has actually seen other CRPS patients. So it's like a Christmas miracle up in here. And I don't have to go to the San Francisco of Indiana anymore. I will miss almost running over people with, my giant red Ford Transit because they go on the electric scooters high as balls.
Mo, we need to go to have a meetup in Sturgis and go to the Hot and Now.
Okay, the chat wants to know, what is nothing working now? I don't understand.
I have no idea.
What did I do? Now none of my buttons work. It's like in the process of shutting down, but I said don't.
What?
I have no idea.
I said don't shut down, so now it like half shut down, so like now my Stream Deck doesn't work, and like what the hell? And
yes, forever wonder. I have learned that this works for everyone. We are trying to sell stuff. Casey Cat, you're making me feel very, very comfortable. No, I need to know some of the things that can go wrong. So become ungovernable.
All right, what does the chat want to know? They wanted to know something about What's new with the Hernandez case? Well, I found here's something new. Matt Hernandez turned himself in. The deal was his lawyer had negotiated a bond deal for him before he turned himself in. So he was supposed to go down to the thing, get booked and fingerprinted, and then walk out of there, right? Because his bond agreement was agreed to. Oh no, that's not what happened. So he goes down there and they throw him in jail. Last I heard, he's still there, and his bond agreement, the judge won't see it or look at it for 24 hours, at least 24 hours.
It's like getting booked on Saturday and then having to wait until Monday.
Yeah. And I don't understand how that happens. Now voice mod won't even open, Brad. Just won't open.
It might just be faster to just go through with a full restart and come back. But I put a link in the chat to how to change the button action so it wouldn't shut down when you accidentally press it.
Oh, really?
Yes.
Interesting. All right, I'll be back. I'm just going to restart.
Okey-dokey.
God dang it.
Well, I mean, so we're back here. You know what's
And there
happening?
were
She's
only
really
two.
she's just taking her bra off. she's redoing with another more strong bra. That's what they're.
God, my brain's not working today. I woke up this morning feeling like crud, and
I'm on a pain hangover kind of thing. So, from Wednesday night into Thursday, it was just not a great leg day, and which stinks because this winter has been pretty good for Indiana. I mean, we really
I just
haven't
got the
had
daily
a winter.
report from my son, and they said that they were outside and loving it because of how warm it is.
I just got a lockdown report because of most of my kids' school are on lockdown because someone just fled a scene of an accident and they don't know where
Jeez.
they're hiding. Because always good.
It's 52 here in Michigan, which is unseasonably warm. They actually opened up the golf course nearby.
Yeah, I mean, honestly, people are like it is Indiana, so the Daisy Dukes never really go away, but people are still using. They are
I'm
still
usually in
out.
like gym shorts just because I tend to run hot, and
All right, I'm back. Buttons work.
Woo!
Great me.
Yes.
I know. I want Judge Borowski to come down.
we need to get you a Judge Borowski clip.
I know. I've heard. I don't even know this guy. Let's find some Judge Borowski fun.
Yes,
Isn't there a
moment.
compilation of Judge what's his name? Borowski? How do you spell
Yes.
that? Judge Borowski.
Oh, don't ask
I
me
know
to
that Jeff sent me like a bunch of moments from him, but that was on our Twitter DM, which is way lost now, because, yeah. Let's see.
I mean, you can.
Preview of the best of Judge Borowski. Oh, this has Nick in it. This is funny. Here's a Law Nerds clip. This should be funny. Let's see. Present, share screen. There we go.
I love when we talk our button pushing out loud. It's to share with you folks how.
It's
Oh,
to
yeah, this is-
avoid dead air. Dead
Well,
air is
that and-
bad.
Here, you have her talking to him, asking him, right? Is that what we just heard?
Yes, but
Okay, thank you. Now,
Thank you.
now
Be quiet now.
And this is the boss. You'll get a chance to follow up.
now, she's
This is the mark. Knock off the insulting behavior towards the court. Knock it off.
Shit! Shut your mouth. She's talking. She's trying to address her dead husband. He's not responding. He's gone, right?
she was responding to whoever was on the phone with her, and she was saying,
Ma'am, that's not what we just heard on the 911 call, is it?
well, I mean, it was different.
Ma'am, that's not what we just heard on the
That's not what you heard on the 911 call, but I was present.
I get that. So
Okay.
you're on the 911 call, and they're asking
What trial was this?
Theodore
That
Edgecombe.
Yeah, that is a trial that is it's sad, but it's also uniquely hilarious, unintentionally, because you have the team up of B. Ivory Lamar, who wants to be the next Ben Crump. You have his other attorney, Friar Tuck. You have, and they may or may not have accused this judge of being a abject racist right before the trial. So,
God.
tends to not work out well for you. Now, they're also accusing look, it's a hilarious one to watch. It's terrible because of what happened, but oh my God, it's the most hilarious trial to watch.
So Brad says we have to watch this one.
You work at a car,
yes.
don't you?
Yes.
All right. Do you recall Ashley Sheldon reaching out to you? Ashley, would you please stand up?
She didn't reach out to me. She just came up to my place of work.
She came up to your place of work.
And she said she was a Milwaukee police.
She said she was the police.
She said she was with the police.
He just called for a sidebar.
Yeah.
I think it froze.
Assistant go and represent
no.
that she was a member of the
Is it back?
police.
Yeah, it's back.
Oh boy. Oh boy.
Oh God, this is not.
You got to go back to when he calls for the
day
sidebar.
could go better for the defense. Sidebar. Oh shit! You.
Let's see.
She came up to your place of work.
And she said she was a Milwaukee police.
She said she was the police.
She said she was with the police.
Sidebar.
Okay. Usually he yells Chambers now, and
yeah,
that would be great.
Oh, that would be great. I have that from that movie on here because I do love that. I love From the Hip, and there's a fantastic clip of the judge screaming in my
It's
chain.
the only word that accurately describes the man, and we can demonstrate just that. Everybody thinks he's an asshole. Son of a bitch. Well, that's good too.
Shut up! What the hell? Court's adjourned. In my chambers. Now.
I love him. I love him. Does this get worse? Like what happens here? It looks like this might be getting worse.
Well, so he does a lot of things where he tells the jury not to eat from the cafeteria because of food poisoning. I think now something about, look, I don't do sports ball, but apparently one of the teams was not, I think it was football, was doing very badly. So he was deciding that he was going to quit his judgeship to go help coach football for the team.
Oh my God.
But he was the best judge ever. He just did not take crap from anyone. And yeah, B. Ivory Lamar was definitely, he thought that this would be his Ben Crump
I don't
moment
remember this
of justice.
trial. Was this before Rittenhouse?
This was right after. So they were trying to prove that basically self-defense couldn't happen if your client was African American because, he was claiming that this immigration attorney who helped, people from Haiti and other places ran him off the road on his bicycle, called him all sorts of the N-words, just went full Cartman on him. So he had to ride his bicycle up, punch him in the face, and then his wife drove to confront him and he shot him in the head. Now,
good Lord.
Yeah. But
like near point blank.
Yeah, they were trying to argue self-defense because allegedly the 65-year-old immigration attorney kind of went into a boxer stance because he'd just gotten punched in the face. He was in fear of his life. So it was an old trial, but it was definitely being kind of, the spin they were using was self-defense and, America is so
racist,
terrible,
yes.
racist that, Kyle Rittenhouse can use this defense, but, Theodore Edgecombe can't, possibly because he ran for 6 months, changed his name, tried to grow out dreadlocks, give a false name as he was running through his gun into, Lake Michigan, other things that Kyle didn't do.
Well,
know.
guys, I this is all very fascinating. I'm going to catch up on this case at some point. But Mr. Fox wants to go for a walk, which I should definitely do.
Yes.
Because I've been sitting here for way too long, and it's 54 degrees outside apparently. So we're going to call it quits. This has been a whole heck of a lot of fun. You guys are super fun. Thanks for being here. And then, Dr. Joe Corcoran's going to be on at 2 o'clock. I would send you over there, but we're an hour behind. 2 o'clock with Ian Runkle on Dr. Corcoran's channel. Get on over there. See you guys.